The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to the Vibe Program. I'm your host, Joe Neerman, a.k.a. Good Logic. Oh, my. Bad collar work. What's the shirt? What's with this shirt? All right, it's a wrinkled shirt. Okay. We have a lot of work to do. A lot of work to do. Very exciting. I enjoy watching attorneys work. I have not watched all but like 2 minutes of this. 2 minutes of this is basically how deep into it. And I was like, I kind of want to watch this with my people. I want to watch it with them. So, but then I wasn't sure. I was like, doing the thing. So I went to locals. I took a poll. I said, you want me to finish the Trump thing? Or you want me to watch this hearing? Now, this hearing involves a man by the name of Harrison Floyd. Mr. Floyd is a co-defendant in the Georgia RICO case that was filed against Donald John Trump. And he was out on $100,000 bond. And there were conditions of his bond. And based on these conditions, where he's not supposed to be intimidating witnesses and doing other various things. And Fani Willis, prosecutor down in the Georgia RICO case, the attorney general down in Fulton County, alleges some of his tweets, some of his comments, some of his stuff was out there and it was threatening others. And she said, I want his bond revoked. I want him chucked back in jail. He's a menace to society. This it tells you it's the state of the world today. It's the state of the world today where it's like, you know what? We want to try and intimidate people from speaking. That's really what it is. You should not be able to speak. So she had a hearing. It was a 4.5 hour hearing. We're going to be watching a little faster than regular speed because, my God, I'm not sitting here for 4.5 hours. Just not doing it. Not going to do it. But it's my locals, folks. When I said, you want me to finish the Trump transcript? You want me to watch this hearing? It was like 85-15. 85%. We're basically saying, let's do the hearing. So we're doing the hearing. It's a great opportunity, a phenomenal opportunity. It's the best opportunity to get a feel for the lawyering skills of at least Fani Willis, who herself is the one who was basically appearing in court today. Not basically, but she herself appeared and tried getting Mr. Floyd thrown behind. It's like another Floyd case. It's another Floyd case right here. This time it's Harrison. Well, anyway, apparently Fani doesn't feel the love for him that I'm sure she feels for George Floyd. Without further ado, let's get it going. Let's get it going. I think that we're close to the start point here. We are going to play this a little faster. I'm going to put this like this, which is my normal standard trial angle. Let's go. Let's do it. You don't want to hear this part. Let's speed you up. I don't have no closed captioning. I'm sorry for that.
Thank you all. Please proceed.
Uh-oh. Why is it so fast? That's 1.25 speed.
All right, let's go on the record with 23 SC 188947 state.
Tell me if this is too fast. I really hope it's not.
We're here today on.
All right, 8614. Beautiful.
Filed last week, and I also received and reviewed yesterday Mr. Floyd's response.
I don't know F you
as
ever.
well as on behalf of the state. And who do you argue on behalf of the defense?
John Morrison.
Morrison, okay.
John Morrison.
All right, Ms. Willis, your floor is yours.
Good morning, good afternoon, Your Honor. I'm Fani Willis.
Isn't that the name of the singer who sang like I got my mind set on you or something like that? No.
Of the state of Georgia. Just want to put some things on the record before we begin, and then the order in which we plan to proceed. We're obviously here because Harrison Floyd is indicted for 3 counts. One is conspiracy.
Into the mic, Fanny. Into the mic. God, you suck. Let me see if I can boost. You suck. I'm already boosted. Damn it. I'm already boosted.
Statute, which, as you know, carries a penalty of 5 to 20 years. The second count is count 30 of the indictment.
So now she's listing off what the charges are.
Statements, a sentence that carries 1 to 2.5 years. And then finally, in count 31, influencing witnesses, which carries a sentence of 2 to 10 years.
Influencing
on
witnesses.
August 29th of 2023, a consent bond was entered in this case, and I know that that's part of the court's official record. The state contends that Mr. Floyd, the defendant that is here before the court today, violated 3 of the 7 conditions of that bond, and those are going to be conditions 5, 6, and 7. As
You really didn't, you guys, you can hear or no? Can't hear, not even worth viewing. Can't hear it, Joe. God. You're saying because I don't have the volume on, or you're saying, let me see if I can find another. Let me see if I can find another audio feed. You suck, Fanny.
All right, let's go on the record.
Oh, this is better. I don't know why
All
this
right,
is
let's
only
go on.
2.5 hours. That's a little disconcerting.
we talk about Ayala and some other cases.
There we go.
Law that 3 of the factors he is a risk for, and then he violated 3 of the conditions of bond.
Let's go back because I know none of you heard anything.
Violating 3 conditions years, and then finally in count 31, influencing witnesses, which carries a sentence of 2 to 10 years. On August the 29th of 2023, a consent bond was entered in this case, and I know that that's part of the court's official record. The state contends that Mr. Floyd, the defendant that is here before the court today, violated 3 of the 7 conditions of that bond, and those are going to be conditions 5, 6, and 7 as outlined there. The state is requesting so that there's no mistake as to what we're asking, that his bond be revoked and that he be
I
removed.
can't explain why this one's 2 hours and 28 minutes.
For violating 3 conditions of the bond. I tell people often I think numerically, and so I often ask that people do that along with me. 3 is going to be a theme here. We believe, Your Honor, as we talk about Ayala and some other case law, that 3 of the factors he is a risk for, and then he violated 3 of the conditions of bond. I want to put some basic case law on the record, and if it's acceptable to the court, I'd like to be able to approach at this time and provide the defense with the first cases. And may I walk freely in the well, or would you like I ask every time? So, Your Honor, just for purposes of the record, I handed you, and the defense is now being handed Ayala versus State, 262 Georgia 704, a 1993 case. We also handed you Hood versus Carson, a 1997 case, and finally Clark versus the State, a 1997 case.
And I'll tell you, it's a smart move for her to get the law out there in front. This tells her, because she's planning on having a hearing, they have witnesses. So she basically is directing the court as to what she wants, with the elements she wants the court to be focusing on here in revoking this bond.
I want to put these on the record from the beginning because they set up the basis of why we're here. In Hood versus Carson, which is cited at 267 Georgia 579, 581, a 1997 case, it is clear that the trial court has power to revoke bond as long as minimal due process is applied. This means a hearing and a chance to be heard. You're obviously meeting that requirement. We are here today before you. Further, in Clark versus State, the trial court has authority to revoke bond if, following a hearing, the trial court determines that the defendant violates the conditions. Clark versus State is cited at 228 Georgia Act 219 at 221.
So this is walking the judge through the reason he has authority to revoke the bond, because it's probably not something he does very often. So this is, again, she said this is clearly set up in Georgian law that you have the authority to do this if you find that he violated the terms of the bond.
The 1997 case. Also, I think it's very important that the court knows that in matters of initially setting bond, the state has the burden of proving by a preponderance. I think that's going to be important. A preponderance of the evidence that the trial court should deny bail to protect the community, and that comes straight out of Ayala, which I would say is the seminal case.
So she's claiming that this case, Ayala, says that it's preponderance of evidence, which is the lowest possible standard of proof. It basically means anything more than 50% that the court agrees with them that he's violated the terms, that he has the right to act.
Based on bond. We'll also.
I'm not telling you what the law is in Georgia right now. I'm just telling you what the district attorney is claiming that the law is.
Providing the court White versus State, which is at 307 Georgia 601, and it just says proof by preponderance simply requires that the evidence show that something is more likely to be true than not. And I will make sure my colleagues provide White versus the State as well. White versus the State is a Georgia Supreme Court, 307 Georgia 601 607 2020. Your Honor, understanding we have the burden in today's hearing, the state's plan is to call 3 witnesses. Those witnesses, again, 3 being our theme, is Assistant Chief Michael Hill. We plan to call Gabriel Sterling, as well as.
I do plan to review Elon versus Media Matters. I think that's an important case. And I think that Elon, owner of Twitter /X, X is now suing Media Matters for purportedly misportraying them as X and Twitter as having racist algorithms or various elements that promote racism. And they claim that Media Matters manipulated searches in order to present findings that are not consistent with the way the algorithm looks for the purposes of basically defaming them and harming their business relations with others. And Elon is furious with Media Matters and trying to go after them. I do plan on covering that lawsuit probably tomorrow. I might do it on Locals though, but that's at goodlogic.locals.com. I might do it there. It depends on how busy tomorrow looks. But I do plan on covering it at some point.
As assistant, as well as Attorney Von Du Bois to meet the preponderance of the evidence standard. With that, I don't know if the defense has opening, but as you direct, we will call our first open witness.
Mr. Morrison.
Good afternoon, Your Honor. One of the things I'd like the court to keep in mind is
He's wearing sneakers.
the spirit of this bond order, which was essentially to make sure that my client doesn't intimidate any witnesses, or that he doesn't collude or with other witnesses regarding what their testimony may be. I believe when the court looks at the complaint about tweets, you're going to find that that never occurred. It was never his intention either, Your Honor. I believe the court will look through, and after it hears the evidence, will find at most, if he came close to the line, the court will have an opportunity to address that. I don't believe that he should be remanded back into the custody of the state. There's no need for that. One of the things that bothers me is if these tweets had so angered or bothered the state, they would have picked up the phone call and called the defense team of my client and said, hey, listen,
Good point.
he's making tweets. We don't like them. Can you do something about them?
Good point.
And we could have addressed the issue.
If he's actually, they're claiming that his tweets were intended to intimidate other witnesses. So why don't you just call defense counsel and say, look, this is intimidating, and if he leaves that up there and does more of that, we're going to try and revoke his bond. Instead, they just went straight to trying to revoke his bond. If it's really that you're trying to protect your witnesses from being intimidated, why wouldn't you take steps to remediate that? It's great. It's a great point. Great point. Remind us how you become members, brother. I don't catch you live enough, but still want to support you. Statutory term limits are still a bad idea. So that's goodlogic.locals.com. Link is in the description. Goodlogic.locals.com. That's the link in the description. That's where you can basically find me all times and support me over there. That's really where I recommend people check me out. Cult follower number 6, Joseph. Why is the mic on the side of the table is right at his hip level? No wonder it sounds that way. Point the mic at your face. That's sound guy Joe right there.
Instead,
he actually is a sound guy. That's what he does.
We believe the reason they filed that motion is my client is showing just how weak the case against him is. And I think he has a right to do that. This is political speech, Your Honor, and they're trying to silence it. Thank you.
Your Honor, may the state
Hitting on
call
First
the-
Amendment, always a good thing.
Your Honor, we're calling Assistant Chief Michael Hill. Your Honor, and we will ask that after Mr. Hill concludes his testimony, that he be allowed to stay in the courtroom.
Your Honor, we would invoke the rule.
Your Honor is aware of the law that regarding detectives and investigators on cases. This is the case that Mr. Hill is working.
Well, he's about to testify, so I don't think he would need to go anywhere. But you're saying there's two other witnesses. The rules of evidence definitely don't apply to bond hearings at all, including the rule of sequestration.
That's true.
But if there's anyone that would like to voluntarily step outside because they think that would be optically better for their case, they may do so. All right, Mr. Hill.
Would you like me to swear him or will you swear the witness?
I think we have Deputy Scott for that.
Thank you, sir. Yes, sir. My name is Michael, Michael, middle initial L, last name Hill, the second.
Good morning, good afternoon, Assistant Chief Hill. Will you please tell the court where you are employed and what your title is?
Good afternoon, madam. Yes, I'm employed with the Fulton County District Attorney's Office. I currently serve as an Assistant Chief Investigator.
And in your capacity as an Assistant Chief Investigator, have you been assigned to work on what we'll refer to as the election interference case, the case that has us in court today?
Yes, ma'am. I've been so assigned for about 2 years now.
As a result of that assignment, have you had the opportunity to subpoena witnesses for proceedings in this matter?
Yes, ma'am, I have.
And also to interview witnesses in the matter?
Yes, ma'am, I have.
Have you also had the opportunity as an Assistant Chief to be familiar and aware with the social media pages, both of defendants as well as witnesses and victims in this case?
Yes, I have. That's correct.
May I approach?
You don't need to ask permission if it's your witness.
I am going to hand you. Take a minute and
Very festive. Yes, very festive. That's a good point, Wrestlertown.
21. Will you take a moment and look at exhibit 1 through 21?
And while he's doing that, I just want to note for everyone, our court reporter is joining us remotely. So at any time you're away from a microphone, just speak up.
Let's see if we can speed this up a little bit here and still be audible.
Have you had an opportunity to look at 1 through 21?
Just a moment.
He's being thorough. He's an investigator. That's what investigators do. They're thorough. Hopefully. Even working for this woman. This person.
Yes, ma'am.
And are you familiar with exhibits 1 through 21?
I am.
Are you familiar with all of them in the same way?
Yes, ma'am, I am.
Okay. And can you tell the court how you're familiar with 1 through 21?
How many of them?
Yes, ma'am. So I'm familiar with exhibits 1 through 21 because they display the social media pages, specifically X, formerly known as Twitter, of defendant Harrison Floyd, as well as witnesses, Mr. Gabriel Sterling, and also Secretary of State, Mr. Brad Raffensperger.
Your Honor, at this time, we're going to ask that State's Exhibit 1 through 21 be admitted into evidence.
I'd rather ask the court to allow me to regard the witnesses to the foundation of these prior to accepting them as figures in evidence.
You're challenging the authenticity of these?
Yes.
All right. I'll give you some leeway there. Mr. Morrison.
Would you like me to do that now? If you would, so you're familiar with these exhibits, correct?
Yes, sir. I'm familiar.
Next to the name, there's a little symbol. Is that correct?
Yes, sir.
What is that symbol?
There's an at, if that's what you mean, the name of the name of the
Is there
page.
a blue check mark at the end of the name?
Are they check
I'm
marked?
not sure, yeah.
You may.
Are they check marked? Are they paying their $8 a month?
Are you yourself a Twitter user, sir?
No, sir, I don't have any social media.
I see.
I don't do social media at all.
If I may, you'll notice here next to Harrison Floyd's name is what?
It's an American flag.
Okay. Next to Mr. Sterling's, there's nothing. But if you look here, what is this next to Miss Ellis's?
Yes, that's a check signifying that her account's been verified.
But the account has been verified.
Correct.
Has Mr. Floyd's account been verified?
Well, according to your example, there's no blue check next to his name. So I would
It's
imagine
not
that means that
verification.
his
If you're not
account is
familiar with
been
Twitter,
verified.
it's not verification. It literally just means I pay $8 a month. I only started doing that myself when I realized that for business reasons, it's crazy for me not to, because people do look more at you if you're a blue check mark, and they also help you in the algorithm. So
Have you verified that these in fact are tweets, those which purport to be from Mr. Floyd are actually in fact from Mr. Floyd?
So you're asking in terms of my authentication or how I verified that these tweets coming from Mr. Floyd, or you asked me to give you that answer?
Have you verified that they came from Mr. Floyd?
So the way that I verified, if that's your question, the way that I was able to verify that these are tweets that were, in fact, that came from Mr. Floyd, were for a few reasons. If you look at Exhibit 1, under Mr. Floyd's page, he has there's several comments. One's God's child. The next is Erica's husband. The next is Harlan's dad. The next is a U.S. Flag that says USMC veteran. The next is 2020 at Team Trump campaign. And then the next is one of 19 defendants in Fulton County.
by the way, if you're wondering who Harrison Floyd is and his involvement here, because he's not a member of Trump's staff, never was. He actually is, I think, the founder of an organization that I believe is called Black Voices for Trump.
And then lastly, you'll see where it says, or underneath all that information, there's a location symbol, and it says North Bethesda, MD, for Maryland. As a part of our investigation in this case, one of the ways that we were able to verify, or actually able to state that, unequivocally this is his page, is that first and foremost, look at the
Anyone
thing
could
that I
do this.
mentioned, Erica's husband. Mr. Floyd is in fact married to Miss Erica DeMare. The next is, you'll see Harlan's dad. And then there's also a little symbol, an emoji symbol of a little girl next to Harlan. Not too long ago, Mr. Floyd and Mr. Mare actually just had a daughter, and I believe her name is Harlan. Also next to that, where you see the U.S. flag,
I can create this now also.
Mr. Floyd is also a former Marine or U.S. veteran. Next, when I just stated the 2020 at Team Trump campaign, during Mr. Floyd's time, or Defendant Floyd's time here in the state of Georgia, he was actually a part of and associated with, I believe, the president of Black Voices for Trump and a supporter of the 2020 Trump campaign. And then the last thing that I'll state here is you see one of 19 defendants in Fulton County. Defendant Floyd is in fact one of 19 defendants on this indictment.
Okay, if I may, continue on. So you're telling me,
Well,
Your Honor, I think we
Morrison,
could cut to this.
let me just kind of cut to the chase here. If you're trying to challenge these saying or reserve the objection that Mr. Floyd did not actually send these tweets or make them, is that what you're trying to do in terms of the authenticity?
I'd like to see the authenticity and the basis for these things. I believe the state has the burden. I'm trying to hold them to their burden.
All right. And although you refer to this multiple times as posted by Mr. Floyd in the opposition's response. Okay. So we're going to admit them over the defense objection.
Whoops. Okay. All right. That's not. If you refer to them as his, you have to refer to them as the purported tweets. That's what you got to do.
And I think they've been tendered as posts that he gathered from Twitter. If you want to retain your argument that Mr. Floyd did not actually post these, I think that goes to the weight, not the admissibility. So we can continue.
And just while we're on that line, did you also see live images, videos, shall we say, from the handle that has just been referred to by the defense? And those live images, were you able to see Defendant Harrison Floyd posting himself, giving live speeches, we'll say, from that particular handle?
Yes, Madam District Attorney, that was actually going to be my next statement. I have viewed live feed or live video, if you will, posted on that Twitter handle.
And who was the person that was posting that?
Mr. Harrison Floyd.
And did the person who posted them and the live speeches that you watched, did it look like the defendant that is here in court today?
Yes.
I will stipulate that that was Mr. Floyd and these videos online.
All right.
You just don't know that it's actually him tweeting himself rather than someone
Your
else.
Honor, I believe 1 through 21 have now been admitted. And you just described in great detail for defense counsel state's exhibit number 1. Is that correct?
Yes, I did.
Okay, I'd like to move on then to state's exhibit number 2. Can you please describe for purposes of the record what state's exhibit number 2 is?
State's exhibit number 2 is the X page of Mr. Gabriel Sterling, the current COO for the Georgia Secretary of State.
And have you confirmed that this is in fact Gabriel Sterling's page?
Yes, ma'am. I have so confirmed. I just myself viewing the page and throughout the course of our investigation. And I've also spoken with counsel for Mr. Sterling, who also confirmed that is his client's Twitter page or X page.
Okay. State's exhibit number 3, will you describe for purposes of the record what state's exhibit number 3 is and what, if any, knowledge you have on state's exhibit number 3?
State's exhibit number 3 is the X page for the Georgia Secretary of State, Mr. Brad Raffensperger. And the same, I confirmed through counsel and also by way of this investigation that is in fact his official page.
Okay, let's move on, sir, to state's exhibit number 4. Will you please describe for purposes of the record what state's exhibit number 4 is and what have you confirmed it in any way?
State's exhibit number 4 is Miss Jenna, witness Jenna Ellis's X page. That was the page that defense counsel referenced the blue check mark next to her name. And I'll also confirm by way of this investigation and also by way of her counsel that is her, in fact, her official page.
State's exhibit number 5, will you describe for purposes of the record what it is and if you have in any way confirmed its authenticity?
Yes, ma'am. That is the X page or Twitter page of the Fulton County District Attorney's Office. And I confirm that through Madam District Attorney.
So they're not telling us what's in here. They're not telling us what's on these pages, what's written that's so relevant. So I'm going to play this a little faster because this is just basically listing off what the exhibits are.
And if I may, Ms. Willis, if we're doing this for 6 through 21, I think maybe the stipulation would cover this.
Yes, Your Honor, but thank you. We're going to get to content at this point, and I am now at state's exhibit number 6, which is relevant to the bond motion.
Nice, Adrian.
State's exhibit number 6. State's exhibit number 6 purports to be from whose page?
Mr. Harrison Floyd.
And what, if anything, can you read into the record the content of state's exhibit number 6 and what it states?
Yes, the content, it states that passing this along to Georgia at Georgia Secretary of State and at Gabriel Sterling, should they be more concerned about interfering in elections, perjury before Congress, lying to DA Fani Willis, or all the above.
And the at Georgia Secretary of State and at Gabriel Sterling is where I want to draw your attention. Have you confirmed?
So I want to hear that. I want to hear that tweet again. This is what he supposedly said. Let's do this a little slower because this is the key. This is the key evidence here, and the reason that she's looking to have him put away.
May I proceed?
Of course.
State's exhibit number 6. State's exhibit number 6 purports to be from whose page?
Mr. Harrison Floyd.
And what, if anything, can you read into the record the content of state's exhibit number 6 and what it states?
Yes, the content, it states that passing this along to Georgia at Georgia Secretary of State and at Gabriel Sterling, should they be more concerned about interfering in elections, perjury before Congress, lying to DA Fani Willis, or all the above.
And the at Georgia Secretary of State and at Gabriel Sterling is where I want to draw your attention. Have you confirmed that by tagging those posts that they did in fact contact witnesses in this case?
Yes, ma'am, they did contact, and my understanding is that Mr. Gabriel Sterling, in fact, has seen this particular notification or communication. Right?
Whether he saw it or not is not relevant.
Post that tagged
Whether he's
Gabriel
trying to
Sterling
get
was
into
able to
it,
communicate.
that could
Yes,
be
ma'am.
relevant because he's
Correct.
trying to intimidate him, not whether or not he was intimidated.
I have now drawn I'm going to ask you to bring your attention to state's exhibit number 6. State's Exhibit number 7. Who is State's Exhibit number 7 for? What is that?
Once again, this is Defendant Floyd.
And what is the content of State's Exhibit number 7?
The content is all caps. We want the truth, followed by 5 exclamation points. And he @s Georgia Secretary of State, @Gabriel Sterling, @Fulton County DA. Next, it states it's accountability time with a clock, and then unseal the ballots.
Through your investigation, were you able to confirm that by placing the @Georgia Secretary of State, that communicated with members of the Georgia Secretary of State's office?
Yes, ma'am, I have.
Objection, Your Honor. Subject to cross-examination. He has no personal knowledge of how Twitter works, how X works. He already said he didn't. So I don't know how he could possibly know that that's communicating with.
As Your Honor is very well aware, hearsay is allowed in a bond motion, and I believe he can testify through hearsay testimony.
Objection. I didn't object to hearsay.
Just speculation.
Personal knowledge.
It's noted, and I think that goes again throughout this hearing. It'll be its weight and not its admissibility, and certainly something you can argue.
All right, sir. Thank you.
How do you have knowledge? Let's specifically go to first of all, is Mr. Sterling a member of the Georgia Secretary of State's office?
Yes, ma'am, that is correct.
And were you able to communicate with him?
Yes, ma'am, I have.
And through that communication, you learned that he was able to see the post at Georgia Secretary of State?
Yes, ma'am.
Was he able also to see the post that tagged him at Gabriel Sterling?
Yes, ma'am.
And so
Anyone could see it. The point is that
do you have first
calling them to look
knowledge
at it.
through that communication?
You get a notification.
Post communicated with him.
When you hit and the person's name, and so their name will go blue if you put in their Twitter handle, and in their notifications they'll see that they have a notification that someone mentioned them in a tweet. So they're really doing a piss poor job of explaining that. But
I have personal knowledge that Mr. Gabriel Sterling has viewed these communications, has seen them. Yes, sir.
That's
and thus
not
they
relevant.
Communicated with him.
Correct.
I would like to draw your attention to State's Exhibit number 8. Would you please read into the record the content of State's Exhibit number 8?
Once again, this is from the X page of Defendant Floyd, and the content is as follows. Black American Dems want the black Trump guy
Hey,
to
Kurt.
tell on the racist white Republicans, but only if it's President Trump, ? LOL. Look, the truth is that @Georgia Secretary of State and @Gabriel Sterling are the pieces of, and it's a
Emoji of, can you just spell that word as opposed to put profanity in the record?
yes, ma'am. It's an emoji of poop or fecal matter emoji. They are the pieces of that emoji.
It's not
you
relevant
should be
whether
mad
they
at.
saw it. It's really not
Make
relevant
elections
because the point is
fair
you're
again.
trying to intimidate them.
And yeah, that's it.
Whether they see it or not is almost
There are 2 hashtags.
whether they laughed it
after
off
that,
or were
Oh,
intimidated
yes,
is
ma'am.
not
The
really
hashtags
relevant.
underneath are #fraud and #Fulton.
Let's move on to State's Exhibit number 9. Can you please read us the content of State's Exhibit number 9?
State's Exhibit number 9, once again,
You're
comes from the X page of Defendant Floyd. And he states, it's over with 5 exclamation points. @Georgia Secretary of State needs to call his lawyer. He's about to go through some things, exclamation point.
So go through some things.
#fraud, #cheating, #election interference.
And I want to be clear here. I think all of this is First Amendment, totally free speech. Ridiculous for this hearing to be had here. It's definitely an effort by Fani Willis. In my personal opinion, it's an effort by Big Fani here to try and silence free speech and intimidate both Mr. Floyd and other witnesses who are out on similar bond from speaking in any way, shape, or form. At the same time, I'm trying to just analyze from the perspective of a judge who may not be looking at her from that perspective and ask myself, it sounds like he's trying to be scary there. Better get a lawyer. It's like his way of trying to frighten it. That's more of a tone of trying to frighten.
Moving on.
Still
to
totally
State's Exhibit number 10.
totally protected
Would you please
speech,
read into
in
the
my
record
opinion.
the content of State's Exhibit number 10.
Once again, from the page of Defendant Floyd, the content is, wow, @Jenna Ellis Esquire. You're a whole mess, girl, exclamation point. So
She
you
is a
didn't
whole
stop
mess.
at stealing people's hard-earned money for your
Yep, she did.
in quotations defense. You're also lying on @Dan Scavino with a question mark, exclamation point, question mark. I guess they don't teach ethics at Harvard Law anymore. And then there's an emoji that I can't make out.
That's not intimidating. He's just saying you suck.
I need to stop here and ask you a question. Is Gabriel Sterling a witness in this case?
Yes, ma'am, he is.
And in fact, specifically to this case, did he testify at a proceeding?
Multiple.
Did he testify specifically at the special purpose grand jury?
Yes, ma'am, he did.
And were transcripts of that testimony turned over to the defense?
Yes, ma'am, they were.
Okay, moving right along, Jenna Ellis, what was her initial status in this case?
Her initial status was one of the 19 defendants.
And what is her status at this time?
She has since pled and she is not a witness for the state.
Did the proffered testimony of Ms. Ellis, was that turned over as witness testimony to the defense in this case?
Yes, ma'am, it was.
Moving right along, let's move to state's exhibit.
The reason she's asking that is she's a witness
exhibit
and the
number
defendant
11
knows
for
she's
you?
a witness.
I do.
Can you please read into the record what the content is of state's exhibit number 11?
It's again from the page of Defendant Floyd. It states, if we are sharing / leaking videos today, ... and then there's an emoji. Like I said from the start, Ruby Freeman was all caps terrified and wouldn't talk to anyone, all caps white, exclamation point. Why? ... question mark.
What are you scared
Because
of?
racism and political terrorism in, I believe this is an emoji of a peach, is still very real, exclamation point.
Oh, in Georgia.
This is a all caps cover up and Fulton County is all caps corrupt.
There is an image on this particular printout. What is that image so that the judge knows exactly what it is he is looking at in state's exhibit number 11?
Your Honor, that is an image of the body cam from the Cobb County Police Department of Miss Ruby Freeman.
Let me ask you.
That's funny.
Do the basis of the initial charges in this case against Mr. Floyd, do they involve Ms. Freeman?
Yes, they do, ma'am.
And to your knowledge, is Ms. Freeman listed 40 times in the state's indictment in this case?
Sadly, she's not indicted, though, which is what they should have done.
Yes, approximately thereabouts, yes.
And is that surrounding the charges against this particular defendant?
Yes, it is.
And this is an image from evidence in the case that is displayed on state's exhibit number 11.
That is correct.
Can we move on to state's exhibit number 12? Can you please put into the record what is displayed on state's exhibit number 12?
Again, from the page of Mr. Harrison Floyd, this is a cover-up, all caps, and Fulton County is corrupt, all caps, with an exclamation point. It is once again that same image of Miss Ruby Freeman at her home via Cobb County Police body cam. And underneath the image, it says, so this begs the question, if Ruby Freeman didn't trust white people to help her, the image, what did she say to the black people? It says that so this begs the question, I'll wait for you to get your popcorn.
Is there a response, and please do not put any profanity, I'd ask you to spell out the word that is profane underneath that comment.
Yes, ma'am. There is a comment, it comes from underneath this post, and the comment comes from @FullFordLeonard, and the statement is bury this, BITCH, under the jail.
All right, let's move on to state's exhibit number 13. I believe the top of this post you just read, there is in this one a different depiction. Are there words now, and who is that an image of on this post?
Once again, it's, I'm sorry, you said state's exhibit, which number?
I'm sorry, 13.
Okay.
You see words in the, first of all, what is that an image of?
It is an image of, once again, Miss Ruby Freeman at her home via Cobb County PD body cam.
Okay, and are there words in that particular depiction that were not present in State's Exhibit number 11 or 12?
Yes, ma'am, there are.
Will you read into the record what those words are?
Those words state, he told her that he wanted to help me.
Is there a comment beneath that in State's Exhibit number 13?
Underneath, there's a comment from @brunettes. Brunettes are great. And the statement or the comment is, Ruby should be in prison with an angry emoji face.
Okay, let's move on to State's number
She should be.
14. Is what's at the top? of
Objection,
State's
it's too
Exhibit number
accurate.
14 simply again the
not
image
gonna
of Miss
That's not
Ruby
gonna fly.
Freeman.
Yes, ma'am, it is.
And can you please read into, and there's the same text from Harrison Floyd that was displayed before, correct?
That's correct.
In an effort to not use as much time, can you just get us to what the comment is under that one?
The comment from @MS Miss Tish TSH 80 is Ruby the racist. Who would have thunk?
Do you consider those to be positive comments?
Not at all, ma'am.
Let's go
Objection.
to State's Exhibit number 15. Again, the same post from Mr. Floyd. There's an image again. Who is this image of for purposes of the record?
Miss Ruby Freeman.
And are there different words that were displayed on the previous post?
They are the same words. He told her that he wanted to help me. Same words.
Again, image from the body cam in this case.
That is correct.
And does it display the witness, Ruby Freeman?
It does.
Is that the same Miss Ruby Freeman that is listed 40 times in this indictment?
Yes, ma'am, it is.
What is the comment underneath?
The comment underneath is from @Justine01848685, and it says racist, and then there's a pig emoji.
Did you find that to be a positive comment?
Not at all, madam.
Moving on to State's Exhibit number 16. I believe that this is a different post. Is that correct?
It is a different post.
Will you, for purposes of the record, read into what the content of this post is?
Again, it comes from the page of Defendant Floyd. It states, yesterday, the Fulton County DA's office leaked proffer videos, and now they are trying to blame my team in order to get a protective order. Look at Fani for DA. If I was going to leak something, it wouldn't be Sidney Powell or Jenna Ellis. It would be this. #Georgia, #fraud.
And then is there an image beneath that?
There is an image, yes.
And what is that image displaying?
The image is displaying the audio captured from the body cam of the Cobb County Police Department.
And who is it capturing, whose voice?
It's capturing the voice of, I believe it's Miss Ruby Freeman, if I remember correctly. Yes.
And let's just for educational purposes, that @Fani4DA, because that @Fani4DA was there, do you have personal knowledge if that communicates with me?
I do have personal knowledge that you have, that it does communicate with you.
If she would like to testify, she can get the stand and testify to this communication with her. I'm just trying to get latitude.
Or I can use hearsay.
Yeah, I think it
Moving
comes
along,
in 3
State's
years.
Exhibit number 17. State's
Yes.
Exhibit number 17,
Yes,
is that before
17.
you?
Yes, 17.
Can you please refer to State's Exhibit number 17 and tell us what the content is?
Yes, once again, it's from Defendant Floyd's page. The content is, so if there is no protective order,
Yeah, I agree with
here's
you
the
as far as
911
way
call
about
that
it.
shows no threats were made, check. Ruby Freeman wanted them to, all caps, come back and tell her what we could do for her, check. Ruby Freeman set up the meeting at the police station, not me, check. And then all caps, I did nothing wrong, #Fulton County.
This is not
Hashtag
trying to
fraud.
intimidate
Let's
anybody.
move on to
It's
State's
ridiculous.
Exhibit number
What about this
18
is
at this
intimidating?
point. Does State's Exhibit number 18 show that exact same post you just accounted in State's Exhibit number 17?
Yes, ma'am, it does.
Can you please read underneath that particular post from Defendant Harrison Floyd what the comment was?
The comment underneath the post is from @South40me, and it states, the whole world knows what she and her daughter did. Absolutely shameful, and all caps, treason.
I'm confused. Is that positive?
No, ma'am, that is not a positive comment.
When
All right,
Jackie and
moving-
Judge, we can strike that last response. Who thinks it's positive or not, it's comment to the evidence, you're the fact finder, you determine.
I'll overrule for the purposes of this hearing.
State's Exhibit
Really?
number 19. Is that before you?
Really?
Assistant Chief Hill.
Yes, ma'am, it is.
Can you read into the record
That's
what the
Judge Scott
content is
McAfee,
of
right?
State's Exhibit number 19?
Really?
Once again, this is from Defendant Floyd's page. The content is, why would my team leak Jenna Ellis and Proffer video?
Why is his opinion as
when there
to
was
whether
better
something is
stuff?
complimentary or
For
not
instance,
relevant?
Ruby Freeman's job was the reconciliation of ballots.
They
She
say what
wasn't
they
even
say.
supposed to be on a scanner. 5 exclamation points follows that. Hashtag fraud, hashtag Fulton County, and hashtag GEORG for Georgia.
And then what is the image that is displayed underneath that?
Underneath, it's an image that captures audio.
Apparently.
And this
That's what this whole hearing is.
Ruby Freeman, captured from the official body cam of the Cobb County Police Department.
And I want you to move along to State's Exhibit number 20.
Now you go to jail.
The same post that was in State's Exhibit 19 is also displayed in State's Exhibit number 20. Is that correct? Oh, actually.
No, ma'am, it's a different post.
Let's move on to State's Exhibit number 20. What does State's Exhibit number 20 state?
State's Exhibit number 20 states, again, it's from the page of Mr. Harrison Floyd. Does this sound like Ruby Freeman is being all caps pressured? Why would DA Fani Willis want to hide this from the public? Hashtag fraud, hashtag Fulton County, and hashtag Georgia.
And there is an image, and who is the image purported from?
Miss Ruby Freeman.
And is it again the body cam video?
That's correct.
Can you please?
Or audio.
I'm sorry, body cam audio. Can you please state for
Well,
purposes?
he can testify to facts, but the point is, it's not. It's an opinion. He's giving his opinion that it's not positive. You're not supposed to be testifying about your opinion. It's not really a whole thing about fact versus law. It's fact versus opinion. Excuse me. But yeah, so now there's no jury here, so that's why the judge is playing fast and loose with the normal rules of evidence, which apparently is what they say is the norm for bond revocation hearings. So a lot of the objections, like hearsay, judges doesn't want to hear about that.
Of the record, what the comment is underneath.
The comment underneath is from @Gandalf419781. And the comment reads, Miss Ruby needs a bodyguard or she's going to get Epsteined or Epsteined.
What does Epstein mean to you?
Objection.
What it means to me is it refers to Mr. Jeffrey Epstein. Who
That's
was
ridiculous.
Convicted.
Objection.
In a sexual assault or sexual.
This is totally calling for a conclusion.
Years ago. And during the year, I believe August of 2019, he was actually incarcerated and found hanging from his cell and is now deceased.
Okay, so is that a term, you're going to be hung from your cell? Is that the way you read that?
The way I interpret it.
How's that
let's
relevant?
clear one thing up. I think we need to have one attorney at a time conducting the hearing, so y'all can choose between yourselves.
We'll move on from this point.
All right, and just to rule on the objection, his characterization of it is not going to be definitive, but overruled for the purposes of the record. All right.
Do all persons in your
That's not a good sign.
do most people need bodyguards in your
Objection. What kind
I
of
wouldn't say
stupid
most
questions?
How about those threatened?
Those threats.
Objection. This
Sure.
is so stupid.
Let's move on to State's Exhibit number 21. State's Exhibit number 21 before you.
Yes, ma'am.
What is anything that State's Exhibit number 21 depict?
It depicts the same image.
Judge
and the same,
Scott McAfee.
Comments from Exhibit 20.
And what, if anything, does it state?
I'm assuming you mean the comment?
Well, first of all, let's read what the defendant, Mr. Floyd's post states, as well as the image, and then the comment and response.
Yes, ma'am. It states Exhibit 21. It states the post actually states, does this sound like Ruby Freeman is being pressured, all caps? Why would DA Fani Willis want to hide from the public? Hashtag fraud, hashtag Fulton County, hashtag Georgia. Again, it is the image of audio from the Cobb County PD body cam from Miss Ruby Freeman. And then the comment.
It's hard to say. It's hard to say. I mean, I don't know. I'm going to reserve judgment. I can't give you an answer on that now. I'm going to have to see more of his work. But and also, this is not really a fair setting because how he acts in front of a jury, it may be a little different from how he acts outside the presence of a jury. So he's being a little fast and loose with the rules, but it is true that it's not a jury hearing.
And
Still,
from a at
and it's a bond
Miss, or
revocation,
at
so
Smoky
some of the rules
Mount
about the windows.
Mystic,
So it's a little tough to
and
say.
it states
I'm not crazy about some of
Ruby is
these
going to
initial
get
rulings.
virtually slaughtered under cross-examination at Trump's trial, and Fani will face charges herself. And then there's a
Slaughtered on
parenthetical if
cross-examination.
she's allowed to live till then.
So
And
Ms. Freeman is allowed to live to testify.
I'm not certain, throughout the course of my investigation of this particular post, I'm not certain if Mr. or Defendant Floyd is referring to Madam District Attorney or if he's referring to Ms. Ruby Freeman.
Objection, Your Honor. Neither of these, this comment wasn't made by Mr. Floyd. This comment was made by a third party. To
Correct.
characterize this as Mr. Floyd referring to Fannie or Ruby was incorrect.
I misspoke.
So,
I
it's
misspoke.
Fani.
We can clarify
But
that for the
you,
record.
so that the record is clear, this is a post in response to Mr. Floyd's
Who
post
cares?
related to Ms. Freeman.
That is correct.
So
I misspoke.
what?
I meant to say the comment was, it was unclear if the comment was
Who gives a
referring
damn?
to
Some
Madam
idiot
District
goes
Attorney
on and
or-
says
I would
something
live or she would live.
crazy.
Correct.
One of
He's
us might not
responsible
live.
for that?
Correct.
And this is in response to this defendant's post.
It's in response to Defendant Floyd's post.
Who cares?
As part of your continued investigation at this time, did you have an opportunity to communicate with defense counsel for Jenna Ellis?
Correct, I have.
And in fact, were you able to determine that those tags effectively communicated with Miss Ellis?
I did determine that those tags, in fact, certainly communicated with Miss Jenna Ellis.
Meaning that when she was tagged, that allowed her to see the communication from Mr. Floyd.
That's correct.
And in fact, in response to that inquiry, I'm gonna hand you what has been marked as State's Exhibit number 23. Can you read silently to yourself State's Exhibit number 23? Have you had an opportunity to do so?
Yes, ma'am.
And is this a communication from the now previous co-defendant, but now witness in this case?
Yes, ma'am.
And was the inquiry made as to both whether these posts communicated with her and whether she was intimidated by them?
Yes, ma'am.
And is State's Exhibit number 23 a text message to that effect?
Yes, ma'am, it is.
Your Honor, at this time, I'm gonna ask that State's Exhibit number 23 be admitted into evidence.
Your
Mr. Morrison.
objection to this is it doesn't have any foundation. It doesn't indicate a time or a date. This is just out of the blue. There's nothing on this that verifies this. This is just rank hearsay. I ask the court if it admits it to give it the little weight that it would deserve.
So I don't have a copy of any of these exhibits, so I can't really speak to what's on it or what is not. But if there's any more you want to lay, and then we can revisit the objection.
So what I've put in State's Exhibit number 23, how did you receive that?
So the contact that you just referenced with defense counsel for Ms. Jenna Ellis was with Mr. Mike Melito. I contacted Mr. Melito. I asked him the questions that you just mentioned about whether or not Ms. Jenna Ellis was communicated with by virtue of these tags, and if she felt threatened or harassed by these communications. And this is the response that Ms. Ellis provided to her counsel and her counsel provided to me.
And did he also state this to you verbally as well?
He also
like
stated
nine
this. He
times
read
hearsay.
actually read this out to me. Yes.
So you received it through him verbally telling it to you, and then he memorialized it via this text message.
That's correct.
And for purposes of the record, was this sent to where?
It was sent to my Fulton County.
Apparently she found the microphone.
Cellular device.
Do you have that with you?
I do.
Do you have it on you now?
And that's true. She could have muted Floyd. She could have blocked him.
I think I left it.
Let me ask you this. At approximately what time did you receive
Great
that?
point, Bobby.
May I approach?
Thank you.
Will you take a moment and open up the message?
Yes.
And if you're worried about your
And
witnesses being
at what
intimidated, why not
time,
have them mute
what day
them?
did you receive that though, so that we're clear for the record?
Today, Tuesday, November 21st, 2023.
And at what time?
This morning at 10:59 a.m.
And this was, again, he spoke this to you verbally
Yes, ma'am, that's correct.
and then memorialized it.
Yes, ma'am, that's correct.
Your Honor, at this time, I would ask that State's Exhibit number 23 be admitted for purposes of this hearing only, and that he be allowed to read it into the record and that it be admitted.
All right, Mr. Morrison, you renew your objection on authentication?
No, Your
All
Honor.
right, Exhibit 23 is admitted.
Can you please read it for purposes of the record?
So in the message, Ms. Jenna Ellis states, I saw it a couple days after it was posted. Yes, I believe it was meant to both intimidate and harass me, and also encourage others to harass me, which others have done in the comments and separate posts following this post and Floyd's comments about me on media. And then there's in the parentheses, which the DA references in their pleading.
One moment, Your Honor.
Thank you. Much obliged.
Moving to another line of questioning. In your investigation on Mr. Floyd, does he have other names that you're aware of?
Yes, Willie Lewis Floyd III is another alias for Mr. Harrison Floyd.
And
Does
Superfly.
he also have in your investigation other open
He's
criminal
also known
charges?
as Brad.
Yes, ma'am, he does a particular federal
His street name is
charge
Brad.
for simple assault against two federal officers.
Your Honor,
Another further for this.
specifically, that's not a matter that was raised in your motion to revoke the bond. Bringing it up here and now, that's the basis upon which they asked the court to rule, would deny my client procedural due process by springing it to him, on him in the middle of this hearing.
All right, well, Mr. Morrison, if that's a line of argument that you think you need more time to respond to, and you need to articulate how that extra time you need, you can do that, and we'll go from there. All right, I think it's Mr. Hill's for cross-examination.
Thank you. And you said that you're not familiar with social media.
No, sir, no, that's not correct.
Well, you're not very familiar. You don't use social media.
In my personal life, no, I do not.
Understand. Now, you said that these are direct communications, is I believe how you characterize that. Is that correct? May I approach, Your Honor?
You may.
You need to what's labeled as Exhibit B for the defense. Are you familiar with this?
Yes, I'm familiar, but you just said that I characterized something as direct communications, and I didn't. I didn't say that.
Okay,
I don't know
Well-
I don't know where you got that from.
all right. So perhaps you didn't, perhaps it was the motion of the state. But there is a mechanism in Twitter or now what's called X for direct communications, direct messaging. Isn't that correct?
Sure.
And this
Good.
is an example of how one would use that app to directly communicate with someone, should they choose to do so.
It appears if you want to send someone a message similar to an email or a text, you could do so via X or Twitter.
Okay, were any of these, what you call messages, conveyed in that manner?
I'm sorry, I don't understand your question.
Or
Yes, you
was
do.
this
Yes, you
messaging,
do.
this direct messaging used by Mr. Floyd to convey messages to any of these witnesses or co-defendants?
I don't have any evidence of that. No.
Is the answer no?
I don't have any evidence of that.
Okay.
No,
You may have. I don't have any evidence of that.
How were
Okay.
they conveyed? To
You
the
can't say
public?
that they did.
I can't say that he
In
did.
fact, all of the messages.
Of course you can.
Exhibits to which you referred to, that isn't the mechanism by which you contend a message was sent to any of these people, is it?
I'm sorry, I don't understand your question, sir.
Okay.
Yes, you do.
The message, the mechanism by which you say Mr. Floyd communicated with people
Yes,
was by putting the ampersand in front of their tag.
correct.
Isn't that really how you reference people?
Well, in the instance of what we're discussing today, that's how he referenced and how he communicated with people.
Well, I mean, when you reference someone, what does that trigger? What happens? Or put an ampersand in front of someone. Did they get an email with the message contained inside?
Nope.
So one of the witnesses in this case, and I think this will answer your question. One of the witnesses in this case, when I spoke to him about the one of the symbols, or when he added them on X, it was conveyed to me that although he did not get the instant notification because he does not have that setting on his cellular device, once he looked at his notifications via his Twitter or X, however you want to reference it, he did see all of the ats that Mr. Floyd continuously utilized.
Now, I noticed that when you look at Exhibit 12, do you have those exhibits in front of you?
Yes, sir, I do.
Okay. This is referencing, and it's repost, it looks like it's 11 seconds long. What is this? Where did this footage come from?
As I mentioned earlier, this is the body cam footage from the Cobb County Police Department, evidence in this case of Ms. Ruby Freeman at her home.
Well, this is in public domain, isn't it?
Well,
I mean, these videos have been released to the public.
some of these videos I have
Well,
seen.
you know,
in,
someone else
public
republished
articles
it.
and news media. I have.
Or are there any of them that you haven't? Or are there any of these that you could say are not in public domain?
None of the videos that we've observed today. No, sir.
So they're all public domain as far as your best knowledge and belief, correct?
Sure.
Okay. And so when he posted something on his account and referenced it, he was conveying his opinion.
I can't. I think you're asking me to speak to the mind of Mr. or Defendant Floyd. I don't
You
know
were
what he was
saying
trying to
what's
convey.
considered nice or polite
Well,
before.
I see here, for instance, on number 12, it states Exhibit 12, where it says an ugly comment by Leonard Fulford. Who's Leonard Fulford?
Yeah, it's the at sign is not an ampersand. You're
I wouldn't
correct.
know. Perhaps Defendant Floyd does. I don't know.
Did you ask Mr. Floyd if he knew who he was?
I haven't spoken to you or the defendant in this case.
And so, in other words, as far as you, he may know, but he may not know, correct?
I don't know, sir.
Okay.
Sure, Clyde.
Well, I understand. But you're complaining
You're the one
about
making the
this
allegation. Good.
comment by,
Objection to the characterization, the state of Georgia through District Attorney Willis complains of the conduct of Mr. Floyd.
And he's supporting that
led to
complaint.
harassment of these witnesses, not Assistant Chief Michael Hill.
That's okay.
Specific-
That's
All right, so Mr.
distinction without a
Morrison,
difference.
what would be your response to that? Or do you want to rephrase?
I'll rephrase it.
All right.
Specifically on Exhibit 12, there's a comment at the bottom that you were asked to highlight and to speak on.
Correct.
And it was made by Leonard Fulford.
Okay.
And you have no knowledge that Mr. Floyd had anything to do with that comment, do you?
No knowledge, sir.
Likewise, on the bottom of State's Exhibit 13,
He thinks
There's
that
a
he's being
Debbie
clever in
J.
the way he's dancing around this. but
which
it's pretty
says
obvious.
brunettes are great. Brunettes are great.
Hmm.
Made an ugly, I'll call it an ugly comment.
Yes, sir.
You don't have any information or knowledge or belief that Mr. Floyd had anything to do with that comment being made, do you?
If you're asking me if Mr. Floyd had anything to do with the comment being made, the comment was made under the post of Mr. Floyd. So I would say, if you're asking me, he did have something to do with that comment being made. How
How?
else would that comment appear under his post if he hadn't made it?
That's
Did he
pretty
make the
stupid.
comment?
Did he make the ugly comment that you just referred to?
Right.
Apparently it comes from Debbie J at Brunettes Are Great.
Is that him?
Do you know who Debbie J is?
I don't.
Objection asked and answered.
No, that was with regard to Mr. Lind, I believe.
I don't recall that one. Why don't we get through it? So you can re-ask the question.
Do you know who Debbie J is?
No, sir, I don't.
Okay. Do you know if he knows who she is, Mr. Floyd?
I don't have that information.
Likewise, on Exhibit 14, there's a MSTSH80. Do you know who that is?
No, sir, I don't know who that is.
Do you know if Mr. Floyd knows who that is?
I wouldn't know, sir.
Do you have any information that, okay, let's go to 15. Justine made a comment.
Yes, sir.
And do you have any information that Mr. Floyd knows who Justine is?
Same answer. No, I don't.
Okay. Or Cindy P on Exhibit 16.
I'm sorry, what's the question?
Or I said, with regard to Exhibit 16, Cindy P.
With regards to Cindy P, does Mr. Floyd knows who she is?
Right.
I wouldn't know that information.
And for all you know, these are just people who are expressing their opinions
Very
based
likely
on
are.
his post. And he has no control over these people, as far as you know, does he?
Does he have control over these people? As far as I know, I have no knowledge. No.
Okay, and he has no control over what they say or don't say, or what their comments are, does he?
I don't know either way.
I don't know
control he
either
has
way.
over these individuals, or if he
Do you have any
has no
reason to
control,
think
or
he
if
has
does.
any control?
Now, I noticed on one of your exhibits, I think maybe it was number 11. Let me see if I can find it. One moment, Your Honor. I've got these out of order. I'm specifically looking for the exhibit where Mr. Floyd talks about, let me find it. Please, Your Honor.
Let's see if we can speed this up a little bit. Move things
Well,
along.
he says, Black American Dems want the black Trump guy to tell on the racist white Republicans only if it's President Trump. Oh, well. Are you familiar with, do you have that exhibit?
Can you, I am familiar with that, but I do not have that exhibit in front of me, sir.
The state put it in its motion. Or have you read the state's motion?
Yes, sir, I have.
Okay. Get my back card, John.
Yeah.
Thank you. Let me show you this right here. And I'm gonna just label this exhibit C. You recognize this post here at the top?
Yes, sir, I do. I do recognize
I
that.
noticed that this portion here at the bottom is a comment, isn't that true?
Seriously.
The portion, which portion, right here?
Yes.
Yeah.
That wasn't in the state's motion. Could you tell us what that said?
Are you asking for this from Brooklyn Flowers?
Yes.
Oh, yeah, so the comment under or Defendant Floyd's post, Black American Dems want the Black Trump guy to tell on the racist white Republicans, but only if it's President Trump, LOL. Look, the truth is that at Georgia Secretary of State and at Gabriel Sterling are the pieces of fecal emoji you should be mad at. Make elections fair again.
He's not
Hashtag
bad.
fraud. Hashtag
He's
Fulton.
okay.
And then there's a comment from Brooklyn
So far.
Brooklyn Flowers that states, "You're in all caps broke and going to waste more money putting forth this all caps election lie. We can't wait to all caps lock you up here in Georgia, as if those 5 days you spent in Fulton jail wasn't enough." And then there's an image that says, warning, coon-fused Negro alert.
Coon spelled C-O-O-N, correct?
Yeah, that's
On the
correct.
beginning of the fused.
Yeah.
The intentional misspelling of the word confused.
Yeah, sure.
Are you aware that this is actually
He seems
what
intelligent,
Mr. Floyd is
Very
responding to is a comment?
but he doesn't seem stupid.
That's not a comment that's in response to his post. That's making him,
If that's what your
him
question
posting
is.
in response to this message he received. Were you aware of that?
No, I'm not aware of that.
Understand?
No, I didn't hear that.
But this isn't in the state's motion, is it?
No, sir.
Okay. Now, if I look through these comments, he makes a comment, for instance, in Exhibit 19. He makes a comment, he says, why would he leak Jenna Ellis and Crawford videos when there's better stuff? For instance, Ruby Freeman's job was the reconciliation of ballots. she wasn't even supposed to be on a scanner. You're familiar with that?
Yes, sir.
Okay. Do you contend that has something to do with the allegations against Mr. Floyd?
I'm sorry, do I contend that? Ask the question.
That him talking about what Ms. Freeman's done?
Stipulate that goes to the facts of the case, if that's what he's looking for, we'll stipulate to it.
No, I believe it doesn't go to the facts of the case.
All right, so the stipulation is rejected. Mr. Morrison, you can ask your question.
Isn't it true that this is just speaking about what her job was or wasn't and what he could release? In other words, that he didn't release the proffers.
Yes, sir. That's correct.
In fact, there's a lot of these where he's talking on the 13th and the 14th about the proffers that were made. And that he's upset that his team has been accused of, or he has been accused of, quote unquote, leaking these proffers. And he denies it.
It's very intimidating. It's very intimidating.
That's true.
And do you believe that there's anything in the bond
he's leaking
conditions
stuff
that prohibits him from defending his good name?
I wouldn't say that there is.
Oh, that's nice. How
Now, likewise,
mighty
I
whitey
noticed
you.
this exhibit 23 that you put together, and how it says, I saw it a couple of days after it was posted.
Yes, sir.
Is mighty white? Is that a racist phrase? Mighty whitey. I want the public's opinion. Is mighty whitey? Is that a racist phrase?
Is she referring to Mr. Floyd's comment about her accepting money for her defense and then really not needing a defense because she entered a plea?
1 second.
Is it more
Yeah,
racist if
correct.
you say it
So
to a white
it
guy or a
states
black guy?
Exhibit 10. That's
What was the date of that comment?
The date of the comment was November the 13th, 2023 at 6:49 p.m.
Okay, and this says, I saw it a couple of days after it was posted. What was the date of exhibit 23?
The date of Exhibit 23?
Yes,
Are you asking,
she sent, is this a text message in exhibit 23?
when was this communication received? Today?
Yes,
Today. This morning.
today.
Yeah, that's what I said earlier, 10:59 a.m.
Okay, I didn't catch that.
Yes, sir. When was this communication received? Today.
Yes. And this is after you've asked her to text you something, is that correct?
So I didn't speak with Ms. Ellis. I spoke with her counsel, Mr. Mike Melito. He spoke with his client regarding the post for Mr. Floyd, dated November the 13th. And that was her response regarding her viewing that post.
That was her response to whom?
That was her response to her counsel.
So this is hearsay on hearsay, correct?
There's like
She spoke
6
to
levels of
counsel,
hearsays.
counsel spoke to you. And now
I
you
said
speak
that
to the
before.
court.
Yeah.
I mean,
True.
that's typically how it goes in criminal investigations, and folks that are represented
It's
by
all
attorneys
hearsay.
speak to
We don't get
their
evidence.
counsel to obtain any information that you need from that individual.
Really?
Although hearsay, we understand is admissible in a bond hearing, that this would not be admissible in a regular court proceeding, correct?
Objection, relevance.
Mr. Morrison, I think you made your point. Let's
Thank you.
keep going.
Okay. Isn't it true that none of Mr. Floyd's posts contain any threats of violence?
No, I wouldn't say that any of his direct comments contain any threats of violence.
Okay. Is there anything in his comments that show he's trying to get witnesses that he's trying to collude with witnesses to change or alter their testimony?
I believe you're asking me to somehow enter the mind of defendant Floyd and trying to figure out what he's trying to do.
No, I'm asking you about the content of the post. Is there
Right.
anything in there that you see
Right.
that indicates he is, if you were one of these people,
So my response to that is, I believe you're trying to ask me about the mind of Defendant Floyd and what
I'm
he's
not.
trying to do. And my response to that is, I can't tell you what he's trying to do to these individuals that have been identified as witnesses in the case, but I can tell you that he is
But you could
certainly
totally.
communicating with these individuals. And
Is he? But
you
is
know,
he?
what effect that may have upon their testimony, what effect that may have upon them feeling harassed, threatened, or intimidated, I believe is up to those individuals. And that, as you saw in State's Exhibit 23,
That'd be funny.
that's how
Be a funny
witness
question.
Jenna Ellis felt by virtue of Mr. Floyd's communications to her.
Well, you're the one who solicited this response from Mrs. Ellis, correct? And she didn't reach out to you and say, hey, I saw this communication and I feel intimidated, did she?
No, she didn't. But I would imagine she may reach out to maybe law enforcement and where she resides or something of that nature. But
Sir, I'm not asking you to.
but no,
imagine.
she didn't. Yeah, she didn't reach out to me to tell me that she felt threatened or harassed or intimidated. This was her response when asked.
Understand, and you've not received any communications from anyone else that you brought to this court showing that anyone was intimidated or felt harassed or pushed to collude or change their testimony, have you?
I believe the other witnesses that are testified today may be able to speak to that.
Okay. Well, I'm asking you.
Have I received any other information about witnesses feeling intimidated or harassed? Is that the question?
I'll move on. Let's see.
Crispy Leg Transport's asking why they're going this hard after the only black man in this trial. There's your little horn. It's just weird. He was the only one put in jail, and now they're trying to send him back to jail. So I think they look at him as a potential weak link, whether it's because of his lack of fame or relative finances compared to others. I definitely think that they're looking that I think they're viewing him as an easier target, potentially. And I do think they want to send a message that we can, you better listen or we're going to have you sent back to jail. If you, and it's really a subtle message to Trump that if they're successful here, that, hey, so you sort of like almost like walking down the road. First person we're going after for speaking out is not Trump, it's someone else. And then we'll go after Trump next if they're successful here. So that I think, but it's an interesting observation you're making there. It's a very interesting observation. I do think he's financially and as far as fame and popularity, he's probably one of the weakest co-defendants. I assume. I mean,
At
I don't
any
know.
point in
I would
time,
guess that likely be the case.
Were you asked to contact any of the attorneys on Mr. Floyd's defense team and say, oh, look, he's making posts that we don't like?
No, sir, I was not asked.
Okay. Were you aware of anyone who thought that they were a problem and they needed to be addressed and sought to address them with his defense team?
Was I aware of anyone that, I'm sorry, ask that question again?
Yes,
I didn't
sure.
Yeah, that was a
I mean,
compound question.
Here's the thing. These comments that have been brought before the court,
Yes, sir.
at any time were they brought to the attention of Mr. Floyd or his defense team and said, look, there's a problem here?
Well, Mr. Floyd made the comment, so he was very much aware of it.
Yeah, that's not the question.
My question is there anyone who made his defense team or him aware that these comments were a problem in the eyes of the state?
Oh, I'm not aware of anyone that reached out to you to say, hey, this is a problem. If that's your question.
Right, or to anyone else on the defense team?
No, sir, not that I'm aware of.
And again, that's important. The reason it's important is because the whole basis of their charge, saying we have to throw him in jail, is because he's intimidating witnesses. So we need to protect our witnesses. We have to protect our witnesses. We have to protect our witnesses. It's almost as if and these threats, these comments are threatening our witnesses. And that's why we throw him in jail. He's a menace to society because he's threatening and trying to intimidate witnesses. So we're going to go to jail. We're going to go to the court and ask the court to do something about it. That's like if a house is on fire and it's burning. It's burning. It's continually burning. And instead of actually like trying to put out the fire and say, hey, look, take down those posts, modify those posts, do something about these posts. Otherwise, because we think you're trying to intimidate. that would be protecting the witnesses. Maybe the witnesses won't even see it. If that's what your real fear is, if there's a legitimate claim, it's a great point that this lawyer is making for Mr. Floyd. It really is, because there's a concept that attorneys are familiar with. If you ever deal with personal injury cases, you trip and fall, all those advertisements you see, there's a concept that's understood by both plaintiffs and defendants that an injured person gets medical treatment. If you're not going for medical treatment, it's not because it's too much of a hassle. It's a reflection that there's not really an injury that's happening here. If this was a threat or potential threat, they would do anything possible to get those posts taken down. And one of those steps would be to reach out to the defendant to the defendant and say, look, if you don't take this down, we're going to come after you for this. Or you go to X, go to Twitter, and you say, you know what, this is intimidation, this is harassment. I would also follow up and say, did anyone report this to X as intimidation, as violating terms of service? Was there any comments like that? That would be another line of questions that I would hope that this attorney would go down in order to establish that it's not intimidating. And you didn't really think it was intimidating. That's why you didn't take any of these steps.
And in any of these comments, he never asked for a response from anyone, did he?
So in State's Exhibit number 6, this is to answer your question.
Sure.
Mr. Floyd says, passing this along to Georgia Secretary of State and Gabrielle Sterling. So he's addressing them. He's communicating with them.
That's not.
And then he asks the question, should they be more concerned about interfering in elections, perjury before Congress, lying to DA Fani Willis, or all the above? And so you're asking, is he asking something of someone? I mean, he's asking a question there, but again, I'm not in the mind of Mr. Floyd, so I don't know if he's asking that.
But you're enough in his mind to say that
or
this
if
is
he's
not
just posing
complimentary.
the question. I just know that he's communicating with these individuals and he's making these comments.
So did you say he's communicating with these individuals?
Yes, sir.
In fact, when I asked you this question earlier,
Sure.
he's not communicating. He's referencing these people. When you put the ampersand in front of someone's handle,
It's an at,
it's a
not
reference
an
to that
ampersand.
person so that other viewers may know who you're talking about, correct? As opposed to sending a direct message.
So perhaps I should answer it this way. I disagree with you in your categorization of that. He's communicating with these folks individually. And the way that I know that is that Mr. Gabriel Sterling, in fact, stated that when he was added, when that communication was made by Mr. Floyd,
It's like
when he opened his cellular device, he went
there's two
into
people who
his
never used Twitter before.
X app, or formerly known as Twitter, and he viewed all.
The real answer that he should be giving is if he didn't want to get their attention, he wouldn't put the ad in. He would just say Gabriel Sterling, Fani Willis. You don't have to use their handle with an at in front of it in order to specifically get their attention. That's the better answer he should have been prepped with if Fani Willis knew what the hell she was doing.
All of the acts that came from Mr. Floyd. So in my mind, and I believe in my mind, that's communicating with.
This is a good sign to me that Fani is
So when someone
kind of
has
incompetent.
the ampersand put in front of their
Oh my
handle,
God.
it simply sends them a notice that they were referenced, correct?
Mr. Sterling was put on notice by Mr. Floyd, defendant Floyd, that he's communicated with him or he's added him. He's made a comment about him.
Or that he's referenced him.
You can say that too.
So,
But I categorize it.
You don't know.
As communicating with.
but you don't know. You're sitting there saying, "Hold on, I'm not in his mind." But all of a sudden, you do know that that's what his intention is.
Often using the ampersand is a way of referencing people for others to know who you're talking about and to likewise let someone know that you've talked about them.
Objection asked and answered.
All right. I also think we're
Beating a dead horse.
cover this after we're done with this, but I do think we're covering things that could very well be taken care of through argument or proffer. And in the interest of finishing today, I think we should refocus on that.
Yes, sure. Willie Lewis, you referenced Willie Lewis.
Hmm?
Do you know who Willie Lewis is?
Willie Lewis Floyd III is an alias for Mr. Harrison Floyd.
You're not aware that that's his father?
I did see another Willie Lewis Floyd that does not have the third at the end, and I always thought that was his father. So you just confirmed that for me. Yeah, I thought that was his dad.
So So when you say that Willie Lewis III is Mr. Floyd, you may have been incorrect, correct?
No, I'm absolutely correct, because I'm talking about Willie Lewis III. That's also the name on Mr. Floyd's, defendant Floyd's North Carolina driver's license, I believe.
Did anyone from the Secretary of State or Mr. Sterling contact your office at the time these posts were made?
No, sir, not that I'm aware of.
Thank you.
Redirect, Your Honor. Start at the end. One of the questions on cross-examination was, did the defendant communicate with, did he ask for responses from people? I'm handing you again what's marked as State's Exhibit number 12, and for brevity's sake, the last sentence by Mr. Floyd in State's Exhibit 12, what does it say?
The last sentence states, "I'll wait for you to get your emoji popcorn."
Okay, and then also here
That's
in
not calling for
State's
people to
Exhibit
comment.
number 8, in the, we'll call it the second sentence here, does he request a response? What does he state?
Look, the truth is that at Georgia Secretary of State and at Gabriel Sterling are the pieces of poop you should be mad at.
So he's not calling for a comment.
Directing people how they should feel, correct?
Correct.
Also, I
How they should feel is not what they should
correct
say.
the record. I'm marking as State's Exhibit 27.
This is insanity.
Motion, and
She sounds so
specifically page
childish.
27 of the defense's motion that they filed is State's Exhibit 27 would already be part of the court's record at page number 7. I'm going to ask that it be
Without
admitted at this time. I'm sorry.
Without objection, Your Honor.
Okay, thank you. The defense attorney asked you when you were on cross-examination how these posts came, and there was, I would call it a racial epithet against Mr. Floyd, but he asked you, how did it come? Was it not in direct response to Mr. Floyd's post? Was the comment that came that he referenced, was it in direct response to Mr. Floyd's post? When you're now looking at it as it is displayed by the defendant in the defendant's motion.
Yes, yes,
Your Honor,
that's correct.
I'm now showing you what I've recently marked as State's Exhibit number 26. State's Exhibit number 26 is the actual bond, consent bond order in this case. Do you recognize it to be that?
I do, ma'am.
Is it part of the court? They'll stipulate it. I'm asking that it be admitted. I'd like you to read into the court record what provision number 5 says.
Provision number 5 reads, "The defendant shall perform no act to intimidate any person known to him to be a co-defendant or witness in this case, or to otherwise obstruct the administration of justice."
What was the status of Janice Ellis?
She was one of the 19 defendants in this case, and she is now a state's witness.
Okay, so she was initially a co-defendant, correct?
Correct.
What is the status of Gabriel Sterling in this case?
He is a witness in this case.
And Miss Ruby Freeman being listed 40 times, what in fact is her status?
She is a witness.
All right. Number 6, can you
Janice
please
Ellis.
read into the record, first of all, the whole provision of provision 6?
Provision 6.
I'm sorry to interject. The document speaks for itself. I mean,
Well, Your Honor, I would ask that he had him on direct. I now have him on, on cross. I would like to make some brief points.
she has redirect, I can understand, but for him to sit here.
No, I take your point, Mr. Cashrock. If we could just refrain from reading things that are already part of the record, and if there's an additional follow-up, we'll just get to that part.
Well, I'm going to ask you to state number 6 because I want to point out some words in number 6. So if you'll read it in its context, and then if you'll tell the court 1, 6, 7, 8.
I'm just going to completely ignore the fact that the objection was sustained.
6, and then tell me what the 11th word in provision number 6 is.
Okay, so the provision is, "The defendant shall not communicate in any way, directly or indirectly, about the facts of this case
She's
with any
looking like,
person
I
known
gotcha.
to him
I
or
gotcha.
her
I
to be
gotcha
a
on the
co-defendant
indirect.
in this case, except through his or her counsel." And the numbered word that you wanted to emphasize was indirectly.
Indirectly communicate.
Indirectly, correct.
Okay, let's read number 7. Can you please read paragraph number 7? Also word number 11. Can you read the whole thing?
Yes, ma'am. So 7, the defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a witness in this case, except through his or her counsel. And the word that you emphasized was indirectly.
And is this bond order in fact entered with Harrison William Prescott Floyd
That's correct.
and signed and agreed to upon by both the state and defense counsel?
It's like
That's
10th
Who
graders
signed
would
this
do
order?
this.
Counsel for the defendant,
And who signed the order from the court?
the Honorable Scott Necker.
That's
Did
interesting.
you have an opportunity to review how many times the posts against Ruby Freeman were viewed?
Yes, I did.
How many?
Not relevant.
Nearly 500,000 times. I think the approximate number is 466,000.
Not
And
relevant.
in your investigations, have you had the
Your
opportunity?
Honor, I object. This is beyond the scope of direct and cross-examination.
And the line of questioning is the reach of these posts, is it right? All right. We can open up that line. I think it's relevant.
And
But that's not what he asked
in
on
the
cross.
investigations,
How's
I
it?
know you said you did not personally have a social media due to your line of work, but have you had the opportunity to investigate social media posts?
Yes.
And is it the culture of social media when one posts?
Objection. He has no way of knowing that.
One moment, Your Honor.
A culture of social media posts. Now
Nothing
all of a sudden
further
he's
from
an
the
expert on that.
All right, recross.
Yeah, so you researched Ruby Freeman's Twitter account, is that correct? Or X account? Is that what you're saying?
Miss Ruby Freeman, I'm not aware if she has an X account. I don't believe she does.
So she didn't even have an account on this social media platform,
Not that I'm aware of, sir.
okay? And you said her name was referenced how many times?
No, sir. The question was how many times was the post in which Mr. Defendant Floyd references Miss Ruby Freeman? How many views did those posts obtain? And the answer to that is nearly 5,466,000.
Okay,
That's the answer to that.
and likewise, Jen Ellis has how many followers?
1 million, I believe.
Over 1 million, correct?
Yeah.
Now, you said that,
You know how many notifications she gets? Do you know how many notifications she gets? Like, I have 40,000. I have 40,000 followers on X. Okay. I usually have, if I've been tweeting at all during the day, I'll have on my notification list. First of all, it caps out at 20. So it'll say 20 plus if there's more than 20. So, and if I'm tweeting throughout the day, so anytime you tweet gets shared, retweeted, or what, there's a notification that comes to you to let you know that. If you get added, there's a notification that comes to you. I'm just explaining for those of you who are not familiar and or don't have an account where you're getting a lot of notifications, which is probably a fair number. So you regularly see a notice when you go there, 20 plus notifications. And so I normally will have somewhere, if I have something like 20 notifications up there, something like that, 30 maybe. My account is 150, and it works exponentially, meaning the larger your account is. So if my account was twice the size, I would probably have, and I'm active on Twitter, I would probably have like 100 notifications. When she has an account which has like 1 million followers, I am positive that she regularly has 150 to 200 notifications. You don't even see them. It gets condensed into view more of your notifications because everything just gets reshared, retweeted. You get referenced here, referenced there. You don't see any of these things. The chances that she would see something that he said, unless he's commenting directly below, like immediately after, the best way to get noticed, if you want to get noticed on Twitter, the best way to get noticed is if you actually catch someone within a minute after they post something and you respond to them with something that catches fire and gets a lot of likes. That's the most likely way. You're looking to get Elon Musk's attention. You're looking to get the attention of someone who has a significant following. If you do that and it catches a lot of likes, so it goes to the top of the comments, that's the most likely way you'll get the attention of someone who has an account of that size. My point being this, yeah, most of us, if someone is tweeting at us, we'll see it. I'll see it likely if someone's tweeting at me because I'll go through my notifications because it's like 20 of them. It's not like 200, 2,000 notifications. But if you're Jenna Ellis, there's no chance she's seeing all her notifications. The chances that she would see something that he said without her purposefully looking for it are very, very small. Very, very small.
Gabriel Sterling's going to be a witness, as well as Ruby Freeman.
Yes, sir. They're on the witness list. Yes.
Witness list?
Yes, sir.
I'm at the
Have
following
you
pro.
turned over that witness
on
list to
Twitter.
us?
I'm not sure of that. I believe you should have that witness list. I'm not sure of that.
Would you be surprised to learn that we don't have a witness list?
I'd be surprised to know that.
Okay. And likewise, let's see, one moment.
Like if you tweet at Elon Musk, he'll never see it. Zero chance he'll see it. Now his account is
Where
much
did you
larger
get
than
that
Jenna's.
$500,000 figure from?
Simple math. Just looked at the viewership from each post that Mr. Floyd references Ms. Ruby Freeman. There's a little number at the bottom. For example, if you look, let's just look at States Exhibit number 6. If you look at the bottom, it'll have the number of views. And so if you just
That's not reflective of anything.
simply look at all the posts in which Mr. Floyd
That's a
references
joke.
Ms. Ruby Freeman, there's several thousand views on many of those posts.
That's nothing.
And when you add them all up, when you calculate them, it adds up to about approximately 466.
That's nothing. That is really nothing. I'll tell you right now. It's nothing. I want to give you an idea, just so you can understand how what a joke that number is. Because first of all, when they say views, it means anyone who has in their feed your thing popping up there and is going through Twitter during that time. It's like there's 1,000 different things that they'll see, and yours will be like one picture. Imagine a collage of like 1,000 faces, and your face is one of those faces in there. So that happened 400,000 times. How many times is that face actually seen? This is so stupid.
That depends on when you copied it, correct?
Say again, sir?
Does that depend on when you copied it?
When you say copy, do you mean
Right,
when
when
it was viewed, when I last saw the number?
Yes.
Oh, yeah, I'm sure it's probably more now.
Okay. And in fact, this whole motion brought by the state and the attention drawn to Mr. Floyd may have amplified every one of those views of those posts, correct?
Possible. I mean, I wouldn't know the answer.
Understand?
Your Honor, just very briefly, if I may.
All right, very briefly.
This is a
I've already
redirect.
admitted into the record 27, which is part of the record anyway, the bond motion. I'm on page 3 of the defense's motion at the second paragraph. 1, 2, 3, 4, 5, 6. Review that to yourself, and will you state what word does the defense refer to Ms. Freeman as?
So in this document, Defendant Floyd's counsel refers to Ms. Ruby Freeman at that line as a favorable witness. She is a favorable witness.
They recognize in their own motion, although they claim they're not witnesses, that she is in fact a
Judge,
witness.
you never said she wasn't a witness. Sorry.
I think that's accurate. I'm not sure what the point is here, where we're going with, but Ms. Willis, what's our next point?
I'm sorry.
What's our next line of inquiry here?
She doesn't know.
In page 8, how do they refer to Ms. Jenna Ellis?
Ms. Jenna Ellis is referred to as a witness. Now,
So they acknowledge them as witnesses, correct?
that's correct.
That's it, Your Honor.
Oh my
All right,
God.
Mr. Hill, thank you. Investigator Hill, just to clean up the record, I think state tendered a exhibit 20. Obviously, we got state's exhibits 1 through 21 that were admitted. Then there was a 23, which was Ms. Ellis's response. I don't know if that was formally admitted. Was there a 22?
There is going to be a 22. It was pre-marked, so not at this time.
Were there other state's exhibits tendered?
26 and 27.
26, all right. those were, I think, admitted by objection.
And goes to the records.
Try to move on to next witness.
I think one of them was just a.
This is just-
record. I think-
This is just tidying stuff. Only trying to
Okay.
steal minutes where we
And
can.
so we'll just need digital copies of those provided, and we'll have those from the court reporter.
Now,
Okay.
just to make sure the court has.
Sure.
all the-
Just a moment before we do that, I just wanted to inquire, just so we are staying on track here. I know the state had mentioned there are 2 more witnesses. Would the defense intend to call any witnesses today?
I don't know yet, Judge. I want to see what they put on.
Okay, but there's a possibility that 1, 2, what is the ceiling of defense witnesses that could possibly be called? Okay, thank you. So potentially we have 3 more witnesses to get through, and we took about, 2 from the state and 1 from the defense. And we've got an hour and a half that we just spent on the first one. So in order for us to finish today, which is the goal, I think there were a lot of things there throughout that first direct that maybe would be more appropriate for a jury. And I'll just note that I'm very familiar with the record and I've read the responses, and I don't need quite as much hand.
Move it
There's
along.
a lot that I think could just be argued and proffered. And if there's an objection to the proffer, you can make that objection.
Move it
How
along.
it works.
That's what
It
he's
says we
saying.
signed it. I promise you that. So with that, I would ask, and I might be a little more willing to step in here if we can't stick to that. So we can call next witness.
We would notify either to be as long.
All right.
We shall call at this time, Mr. Gabriel Sterling.
Move it along. Get her up there. We're moving along. We're at double speed here. Double speed. Lightning speed. This is lightning round. Get her up there. Come on. Oh, it's a dude. Oh, is it Gabriel Sterling? Ah, I hate this sick
Robert
schmuck.
Gabriel Sterling, ROBERT GABRIEL STERLING.
Good afternoon, Mr. Sterling. Where are you employed?
The Office of Georgia Secretary of State.
All right, and have you had an opportunity to, did you have an opportunity to testify at the special purpose grand jury?
Yes,
in the
ma'am.
matter that brings us here today?
Yes, ma'am.
I'm going to show you a couple of exhibits that have already been admitted into evidence. I'm going to ask you some very brief questions on them. Are you familiar with State's Exhibit Number 2?
Yes, ma'am.
Okay, and just for purposes of the record, if someone tags you at gabrielsterling.org, do you in fact receive those? If they tag you here, then I'll go back and answer that.
GabrielSterling.org is my old website. I think you're asking
I'm
about.
sorry,
my-
at Gabriel Sterling, yes.
Yes,
And also, if someone tags at Georgia Secretary of State, is that something that a member of the Secretary of State's office, to include you, would receive?
yes, ma'am.
Okay, and
This is
moving
his
on to
Twitter
State's
thing.
Exhibit number
70,000
7,
followers.
have you in
He ain't
fact
seen
seen this
nothing.
post? State's Exhibit number 7,
Yes, ma'am.
and is that because you were tagged at Gabriel Sterling?
Yes, ma'am.
Moving on to State's Exhibit number 9, are you familiar with State's Exhibit 9?
Yes, ma'am.
And is that because it was tagged at Georgia Secretary of State?
Yes, ma'am.
Is that what allowed are these tags what allowed these messages to communicate with you?
When you're tagged, it shows up in your feed of.
Yeah,
items
she's
that
very
mention you,
radical.
So yes.
Okay, and then finally, the last one,
Fairly
State's
stupid.
Exhibit number 8. Are you familiar with?
She is
State's
all
Exhibit
over them.
number
It's
8?
ridiculous. This is like so weird.
Yes, ma'am.
And is that again because you were tagged both at Georgia Secretary of State and at Gabriel Sterling?
Yes, ma'am.
Do you enjoy being called a piece of fecal matter?
No, ma'am.
You're very popular, Matt. Very, very popular.
Are you a witness in this matter?
I don't know.
Yes, ma'am.
Potentially. Are you a witness against this defendant?
Thank you.
Oh, that's fast.
Mr. Sterling, you're not a fan of Donald Trump, are you?
Objection, relevance.
Oh,
Goes to
oh.
bias.
Bias against Mr. Floyd. All right. We'll give you a little leeway on this.
You know Mr. Floyd is a Trump supporter, don't you?
Yes,
By the way, the state reached out to you about these posts, didn't they?
yes, sir.
And they asked you to
Good.
come in and testify about this.
They subpoenaed me, yes.
They subpoenaed you to come here.
Yes.
These posts aren't threatening to you. They may not be nice, but they're not threatening and intimidating to you, are they?
It's par for the course when you're in a public figure.
So you are a public figure.
Yes.
Good.
When you're tagged, the ampersand you said shows up in your feed.
Yes, sir.
That is a mention of who you are, correct?
The way it works is essentially when you go to your, for people who don't know Twitter or X, you'll have notification in the bottom part saying if there's a little bell, basically, if something mentioned your name or anything that you follow, you'll have a little red number.
This is
in
the
there
bell
for
he's
you
talking
things
about.
that happened since the last time you were there, and then you would go to that and you would see things where you were tagged in. Yes, sir.
Okay. I don't know if you have State's Exhibit 7 in front of you.
I have nothing in front of me, sir.
Ron, may I approach briefly?
Showing you State 7. Where Mr. Floyd says, we want the truth. It's accountability time, unseal the ballots. Are you aware of other cases where ballots are sealed?
There is a matter in Fulton County, yes, sir. Actually, it's being done in front of a Henry County judge, if memory serves.
So that post could be talking about that case.
I don't know what Mr. Floyd said, sir.
Right. We don't know what case this is referring to.
Not particularly, no, sir. Yes, sir.
Good. Great job. Great job.
Are you also, you have approximately 67,000 followers on your account?
70,600.
70,600. How many direct messages do you get a day?
It varies.
How many times you added it?
Rough estimate?
I'll do it more like the week. I get 3 or 4 a week, maybe, depending. Like right now, I'm going
This is
back
the
and forth
ad.
with
This is
gentlemen
the
about
direct
something going on
message
in
over
licensing.
here.
Okay.
That's a different thing
then-
than this. He asked
How
the
many
wrong
times a
question.
day are you tagged
Ah, there you
on
go.
posts?
I have no way of knowing that, sir.
A lot.
It's common, yes, sir.
And it's common that you might miss. You're not paying attention to your notification section every single post that goes through there, are you?
When I'm tagged, I generally go take a look at it, yes, sir. But I mean, it's not so overwhelming that
Really?
I can't, but I don't look at it every day or every hour now.
And if you were threatened or intimidated, would you contact law enforcement?
If I thought something rose to that level, I would contact law enforcement.
And you didn't contact law enforcement in this case?
No, sir.
Your Honor, I have nothing further.
Okay, all right. Thank you, Mr. Sterling.
Thank you.
Can this witness be excused from subpoena?
Your Honor, at this time, I'll call
Yes, sir.
Bond, the voice,
I'm sorry,
Bond, the vote,
can you spell that for the record?
EUBOSE, but we won't let him spell it as well.
Okay.
So the state got it right.
All right.
This is our final witness.
He's such a turd. He's such a turd.
Madam Prosecutor, who is the next witness? Vaughn?
Mhm.
Is that law enforcement?
He is not.
That witness?
Yes.
Actually, I'm going to delete that. I'm going to delete that one. Let me delete that one. I want to make another one where I'm retweeting. I'm going to retweet this. Oh, I
My
can't
name is
miss.
Von Dubose, VONDUBOSE.
And, Mr. DeBose, will you please tell the, for purposes of the record, would you state what your profession is?
I'm an attorney.
And do you in fact practice in this jurisdiction as well as others?
Yes,
Do you have a client that is a witness in this case?
I do.
Can you please state for purposes of the record what your client's name is?
Ruby Freeman.
I am going to hand you
what is been marked as state's exhibit number 22? Can you tell me what state's exhibit number 22 represents?
Yes, I can.
Jack.
Tell us, please.
Yes, it's a threat level report that we have a third-party vendor who will monitor online activity regarding potential threats for Ms. Freeman and her daughter and their family.
Why do you have a threat monitoring report that relates to Ms. Freeman and her daughter? And what is her daughter's name for purposes of the record?
Her daughter is Shay Moss.
You also represent Ms. Moss?
I do.
Is Ms. Moss a witness in this matter?
Yes, to my understanding.
And in fact, have you accompanied them to proceedings in this matter?
I have.
Why did you hire this company to do threat assessment on your two clients? Is that something you do for every client you have?
No.
Why did you find it necessary to do for this particular client?
Well, just the level of threats since all of this began for Ruby and Shay have been quite high. She's been listed on death lists. She's been told that she needs to leave her house by the FBI. So we just need.
You guys think he's going to see it? You think he's going to see it?
There, whether there are any spikes or flashes in the threat level. So this company has been retained to do that.
And in fact, the threat levels at one point prior to this matter was so high, she had to relocate from her home.
Absolutely.
And that was on the recommendation of the FBI.
Yes, it was.
I'm trying to see if I can like bait him out. If he sees it.
Prior to the state contacting you, were you made aware of some comments by
Ruby Freeman, for those of you who are unfamiliar, don't remember the name. You probably would remember the name if we pulled you back in time to 2020 version of you, if you were following anything that was happening with the trial. Ruby Freeman was one of the election poll workers. Who was there on video, and the whole dispute as to whether she was running the same stuff through the machine over and over again, and whether she was some sort of Democratic operative, and the whole thing with the ballots under the table and that whole thing. So she was at the center. She was one of the people who stayed there when everyone ran out from that flood in Fulton County and was purportedly counting the same ballots over and over again and playing all sorts of shenanigans in Fulton County. So that's Ruby Freeman. She and her daughter. I remember her daughter's name, but that's who's being referenced. Maybe. I thought sitting on something was sufficiently vague. Like you could be sitting on a secret.
a defendant in this case on social media?
Yes, I was.
What defendant were you aware of making comments as it related to your
Did I say
client,
why?
Ms. Freeman,
Did I say what?
prior to the state ever contacting
Did I
you?
really say
Mr.
what?
Harrison Floyd.
How is it that you became aware that Mr. Floyd, the defendant in this matter, was making comments about your client?
Well, a couple of my co-counsel informed me that there were some comments being made and that we needed to huddle together and have a session to assess what was going on and to determine whether there were anything, measures that needed to be taken by us or by Ms. Freeman and Ms. Moss.
To keep them safe.
To keep them safe, absolutely.
And in fact, as a result of these comments made by Mr. Floyd in relationship to this matter, did you call what you referred to me as a spike?
Yes.
Can you educate the court as you educated me as to what a spike is and why that may cause you some concern as well as the other team that represents her?
Sure. So a spike is simply a time at which online activity regarding Ms. Freeman, and her name is mentioned at a particular time, and you can tie spikes in this report to actual posts and things of that nature. So I believe this is the report that tied a particular spike in that online activity to the tweets from Mr. Floyd. And traditionally, as these
So
things
when
go
her
in
name
this
is
case,
mentioned, there's a
Freeman,
spike in
this
her
is the
name being
beginning
mentioned,
of
as opposed to never being
threats.
mentioned when there's no
So
spike
that
in her
got our
name being
attention.
mentioned.
We were very concerned about that, and we wanted to make sure we addressed it appropriately.
That is ridiculous.
And so I don't want you to get into security precautions you took, but were in
Every time
fact
she jumps in
some
the pool
precautions taken
of
as a
water,
result of
she gets water on her.
One moment.
and we get concerned that she's going to be wet.
No further questions.
Your Honor, at this time, I'd ask that State Exhibit 22 be admitted into evidence.
Subjects crossed.
State Exhibit 22, you need to clarify some things before its entry. All right, well, let's start with that.
Okay. This is the report that you had
It's very,
put
it's
together.
microaggressions.
The report is generated periodically.
Who is Protect Democracy?
Protect Democracy is a not-for-profit.
And so they're the ones that are generating this report?
No.
Why are they on here? Are you Jensen Hughes? Is that your firm?
No.
Why is Protect Democracy here for the date of November 15th, 2023?
Protect Democracy is counsel Ms. Freeman and Ms. Moss.
Are there also an attorney?
Yes.
Okay, I'm sorry, I didn't know.
Yes.
So this report, all these pages, this isn't all just Harrison Floyd, is it?
Not to my knowledge.
Right. It's other people like the Gateway Pundit, correct?
I think they mentioned, yeah.
All these posts, all these videos, they're in the public domain, are they not?
What post?
These videos of Ms. Freeman at the Cobb County station.
I don't know if all of them are or not.
So you have no idea whether these things are in the public domain already?
When you say these things, what are you referring to?
Oh, I'm sorry. Ms. Ruby Freeman's videos of her in the Cobb County police station being on body cam that night of January the 4th or 5th, 2021.
Okay. And I'm having trouble kind of understanding which particular videos you're talking about. It's hard.
All the
I don't
Cobb
have
County,
them in front of me, but
all the Cobb County police videos.
I don't know that for sure. I don't know if they're all in the public domain.
You're her attorney, right?
Yes.
Charged with protecting her?
Sorry?
Charged with protecting her?
I'm charged with representing her as counsel.
So you're representing her as counsel and you haven't researched what's out in the public domain about her?
That's not accurate.
Well, you don't know whether any of the Cobb County videos are in the public domain, right?
Objection.
That's not.
All right, and also, Mr. Kaczmarov, I think the focus here was supposed to be the admissibility of State Exhibit 22. That's the
Yeah, I'm
pending
sorry,
question.
Judge. So this also includes other people apart from Harrison Floyd, does it not? Like the Gateway Pundit.
The state will stipulate that he is correct, that it is.
All right, and again, I think you're getting into argument concerning the document, not necessarily its authenticity.
I'm not going to authenticity, but actually to relevance, because they're putting this in for stats and a spike, but they've included not just Harrison Floyd, but influencers on social media that have millions of followers.
And I think that goes to its weight, not its admissibility. So I'll admit 22 over objection, and you can go from there.
Okay.
I guess technically,
Ms. Ruby's address is private, correct?
I guess that's a fair call by the judge.
Phone number is private, correct?
When you say private, do you mean?
It's not out in public.
Well, her address has been out in public, her previous address.
And have you spoken to her in the past few days
Yes,
about this issue?
yes.
Okay.
And did she call the police about this issue?
No.
So not really a threat. It's not calling the police. It's not really a. I didn't feel like she
Ms.
was-
Freeman also has a lawsuit against the Gateway Pundit, does she not?
That's correct.
And so this report was generated for that lawsuit?
This attorney on the stand, the witness,
Nothing in the post that you've seen
you can see he's thinking,
constitutes a threat under Georgia law, does it?
and he's not.
Which
He's
post are you talking
he's displaying
Post that the
intelligence.
state showed you about Ms. Freeman today.
about? You're gonna have to show me what law you're talking about. I'm not quite sure what you mean when you said threat under Georgia law.
You're an attorney, right?
A civil attorney,
Civil attorney, but you know what it means to say threats, don't you?
very particular about Georgia law.
So you don't know what a threat is.
Objection asked and answered.
Overruled, I don't think we've gotten an answer yet.
So what's the question?
You know what a threat is?
I do.
There's nothing in his posts that are threatening, is there?
No, I disagree.
There's nothing in those posts that are intimidating to a reasonable person, are they?
I disagree.
I'm not talking about the follow-up posts. I'm talking about Mr. Harrison Floyd's posts.
I am too.
He's not budging.
The threat level on this report doesn't show that the spike came from Harrison Floyd, does it?
It does.
It shows that the spike came from a conglomeration of sources. Have you read the report?
I have.
Judge, I have nothing further.
You
Any
redirect.
other questions for this witness from the state?
Okay, thank you, Mr. Du Bois.
Exhibit.
That concludes witnesses for the state, and we do have some argument we'd like to make.
Of course, Ms. Willis. Any evidence on behalf of the defense?
No, Your Honor, we don't need.
Okay. Yeah.
What happened? It's still playing.
5 minutes break would be nice for.
Let's do that. All right, we are back on the record. Ms. Willis.
No, I'm gonna, waiving, opening, closing, and I'll reserve everything for you.
All right, I think the state would still have the burden for revocation, so we'll turn it over to the defense. Mr. Catchraw.
I believe this is a more condensed version, so I don't think we're
Definitely,
missing
Your Honor,
anything, even though it's
support.
2 hours shorter than the other video I was looking at before.
I think if we anchor ourselves to the words of the order that you entered, I think that's dispositive. I begin there because there's really 3 things that the state is complaining about. One is the concept of intimidation or harassment.
I think
Is that a
this is the closing
subjective standard
arguments.
or an objective standard? I would submit, Your Honor, it's an objective standard. Otherwise, this order is vague. You wouldn't know what those things constitute. Threats and intimidation are well defined in Georgia law. None of these posts amount to a threat or intimidation. That is to say, none put a reasonable person in fear for their safety. The witnesses today you heard did not support that paragraph. That would be paragraph 5 of your order. There's no violations there. The remaining 2 paragraphs I would submit, paragraphs 6 and 7, there's no violations there either. Those 2 paragraphs state that you're not supposed to have any communication with a person or witness or a co-defendant in this case about the facts of this case. That's what those 2, directly or indirectly. So if you look at that order, the only thing that the state tries to argue is that these handle tags on Twitter constitute communication. They said that over and over and over. The problem with that goes against Twitter's own help rules. And I apologize, I actually brought up my phone and I would ask the court to take judicial notice of that. And it says the ampersand sign is used to call out usernames in posts. Hello @X. People will use your username to mention you in posts, send you a message, or link to your profile. So that in the Twitterverse, that's used in a wide variety of ways.
Sure, but the practical effect is that the person mentioned gets a notification, do they not?
They do, Your Honor, and I would submit to you, for instance, Jenna Ellis has 1 million followers. I would submit to you, if you typed in Jenna Ellis and give the money back, you would see hundreds of thousands of independent tweets saying the exact same thing. So I find it hard to believe that Ms. Ellis would have seen that unless she were specifically called out about it, which is the other thing. None of these witnesses here contacted the state. The state chose of its own volition to contact them.
Just to be clear, what you're arguing is not so much that it was impossible that Mr. Floyd's comments reached any of these witnesses, just that it was improbable.
It was improbable, yes. It could, surely they could see that if it shows up in their feed, surely they could see it. But that's the other thing. Were they talking about the facts of this case? And I can go through each one of the Twitter posts that.
Well, it says that they can't communicate, right?
Not just communicate, can't communicate about the facts of this case.
And so, for example, with the one with Miss Ellis, how would that not be a communication about the facts of this case if it's solely referencing a proper session?
Because first, it's public in the public domain. Number one.
Well, that wasn't a precondition, right? Of the bond
No,
order.
but she's not. I'm just pointing out the fact that her video is in the public domain. He's commenting on the video. It is a public comment. He's allowed to do that under the First Amendment. So the idea that this is somehow not a permissible communication, it's a problem because that begs the question about the facts of this case. What facts? The ones as they develop, the ones that are ongoing, the facts in the indictment, which also spurs another question. Miss Ellis won't even be a witness against us. I mean, I know that the state's going to say, well, she's a RICO witness. we don't have anything to do with Miss Ellis. Not only that, we don't even have a witness list. All we know, we have unindicted co-conspirators. We have to guess who the witnesses might be.
That's a good point.
The state
Very
has
good
said
point.
that they have sent us discovery, but that discovery is like a football field size haystack about 10 feet high, and we're looking for 5 needles in it. I have to go through 30 or 40 folders and click down only to find out that the file that I'm looking at is a GIF image. So the idea that, well, we've turned it over. I don't know if they turned it over. I had to search. I had to ask the other day for one of the witnesses' grand jury testimony that they said they had just received. So I don't know what the state has or what they don't have. I don't know who their witnesses are. I don't. That's of no concern to me.
Sure, but I think you have a pretty good indication of who they're going to be, at least some of them.
I didn't know Gabriel Sterling was a witness. Had no idea, Judge. Zero.
But what about the Secretary of State?
Right, but that's also a public account. He's not barred from calling out the Secretary of State. Now, if we don't like that, we should change the bond order. I would submit, Judge, that would be the appropriate remedy. The state surely, and you read my motion, the state, or my opposition rather, the state knows how to address social media posts as it did with President Trump.
And so, again, this idea that someone has pleaded guilty and an explicit condition of their plea is that they're going to be a cooperating witness. You still don't think that's sufficient notice that that person's going to be a witness in the case?
No. I stipulate. So we're clear on the record. She's a witness in this case, not against him.
Well, she's a witness in the prosecution against him. He's going to be sitting presumably at one of many tables, and then it will be in the state's case in chief where he is a defendant.
I may be presumptuous in thinking that won't happen, but Judge, she's a witness to be sure, but nothing in that bond order prohibits him from contacting a witness. Nothing in the bond order prohibits him from contacting a co-defendant. They just can't contact each other about the facts of this case. They could call him and say, hey, you want to come over for dinner tonight? As long as we don't talk about the facts of the case, they can do that. That's why I pinpoint those words. Communicate with. That's the other part of this. It's not simply to shout out into the Twitterverse. That's like going to Mercedes-Benz Stadium and being on one side and Miss Ellis is on the other side and during the middle of an Atlanta Falcons game. And he yells out, hey, Jenna, give the money back. If she happens to hear it, and maybe the crowd starts chanting, give the money back. She's a public figure as well. 1 million followers, Judge. 1 million. She wasn't worried. She didn't know anything about it. She didn't reach out. So we're not contending that she's not a witness. The thrust of this is collusion. Are you getting together with other witnesses to change stories? I don't see any other purpose for those paragraphs 6 and 7. So I would submit, Your Honor, if we pay attention, if we're faithful to the text of the order, paragraphs 6 and 7 are clear. Communicate with, not communicate to, not say something about, because that's what this really amounts to, say something about. You heard Assistant Chief Hill, I believe his testimony was, he didn't know what was in the mind of Mr. Floyd. Mr. Sterling contended that one of the posts, or he agreed, one of the posts he wasn't even sure what case it applied to, but he knew there was another case pending that had sealed ballots in it. So yes, when you're tagged, it shows up in your feed. But like I said, Judge, you're not required to, it's not a requirement in Twitter. I post things all the time where I will put an @ symbol. Do I think that the other person might see it? It's possible. I don't care. I want to post. It's a political forum. That's the whole purpose of ideas. I mean, you find something offensive, you don't have the right not to be offensive. I mean, in order to think, you have to risk being offensive. Do you not?
So, yeah, just taking that point, I just want to focus here. I think maybe the Twitter aspect of this may be confusing it, but what would be the functional difference of Mr. Floyd having just written a letter and mailed it to him and assuming that Miss Ellis gets 1,000 letters a day?
Because that shows his intent. His intent is to make direct contact. There's a mechanism in Twitter for direct notification, direct contact. You can send a message directly to the person, as opposed to the Twitterverse, the forum, the public forum, putting out a political message, a political opinion. He can do all of those things. He can say, I'm innocent. I didn't do this. Now, is he talking about the facts of this case? Well, I'm sure the district attorney will try to use this stuff at trial, perhaps. But Harrison Floyd has never said that anything against Ruby Freeman. By the way, Ruby Freeman doesn't even have a social media post. And I want to bring this report up. I would encourage you, Judge, look at page 2. A majority of these mentions related to commentary about the latest post from the Gateway Pundit regarding Ms. Freeman and Mrs. Moss's alleged participation in election fraud. Her attorney said this report was about his posts, but I don't see how you can compare the two. Gateway Pundit has a slew of followers. His Twitter account is 25,000 people, not 2 million, not 3 million, not the million that Jenna Ellis has, not the 75,000 that Mr. Sterling has, or the 114,000 that Ms. Willis has on one of her accounts, and however many others she has in her other account. A lot of this has to do with being in the public domain as well. Nothing in any of the posts that he wrote about Ms. Freeman show any threats of intimidation. They are merely statements that he is claiming, I'm innocent, I haven't done anything wrong.
He's a little
Which is
stilted,
why I said in my motion,
but he's making good
or
points.
my opposition rather, that this court should be faithful to the text of the bond order. If we have an issue with it, Judge, we're very amenable. You heard my co-counsel say earlier, all they had to do was call us. Mr. Floyd has come back to Georgia voluntarily. The first time when he turned himself in, he was put in jail, wasn't able to get a bond hearing until Your Honor got involved. And you got back and were able to get him a bond. He appreciates that immensely. He came back today just because I told him to. He's a law-abiding citizen. Yes, there are some other things pending, but that has nothing to do with this hearing. Zero. If the court tells him, look, I want you to tone it down, I don't want you to mention Ruby Freeman, he'll do what you tell him to do. It's not that at that point, it's not about a First Amendment argument. We'll let that go, Judge. If his rights to speech are in jeopardy versus his freedoms and liberty, his personal restraint, Judge, he's going to opt for his personal liberty.
Now, this I don't like, because, and I understand that this attorney is doing what he has to do. His goal is, I need to keep my client out of jail. I need to keep his bond from being revoked. He's got to do that. But it's very frustrating that, he's pretty much offering, if you want him to bend the knee, he'll bend the knee. Whatever it is that you want him to bend and kiss the ring, he's willing to bend the knee and kiss the ring. Not as far as turning states, the way Janice Ellis did, but that he's willing to basically mute himself, even if it's not something that he legally should be required to, and he'll do that going forward. I can understand why this lawyer is making that argument. I can understand why his client directed him, that he wants him to make this offer to the court. It's just frustrating. It's frustrating because I think that this is ridiculous that he's even been hailed into court for this, and it's sad. It's a sad state of affairs. It really is.
So I would submit
But I don't fault him at all for this. He was trying to stay out of jail. I get it, and it's the right call for him. So,
Honor, that this whole tactic is somewhat of a retaliation. If you look at when the motion was generated, I believe the motion was generated on the November 15th, just after this court's hearing, because we received it 2 hours after the court's hearing.
Yeah, he is giving him an out.
Ms. Willis was in
right.
DC. She personally signed the motion, or they put her signature on it. She was attending an event with a women's summit and also a fundraiser. But the reason why I say it was cobbled together hastily was because Jenna Ellis's post is on the 13th, and she says she saw it a couple of days later. Well, I would submit, Your Honor, that she was raised, the awareness of that was raised to her by the state. I just don't see 1 million followers, how that could happen. And so with that, Judge, I would just check one thing here. Yes, and there's also on Twitter, if there's a post that's found offensive or threatening, it can be reported. And people should do that. If they want to generate reports, they can. But it would be just as effective to call out posts and say these are inappropriate posts. With that, Judge, I would conclude.
Ms. State, we heard. Your Honor, it's always like when me and the defense can agree. We agree on something. We just ask you to strictly rely on the order that you signed. And as Your Honor knows, I only have to prove he violated this order one way. And
that would be enough to revoke his bond. So I'll lead you to number 7 that says the defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a witness in this case, except through his or her counsel. It's clear, they signed it, they understood it. Now I'm gonna take some time and go through a PowerPoint. I didn't ask any questions today to offend you. I asked you because of the absurdity of their argument. My team asked me to tone it down because I referred to it initially as lunacy, and they asked that I refer to it as absurdity. I would submit you can use either adjective. Put it up, please. I need a screen share, Your Honor.
Which account is joining to
What account
host?
is joining?
Mr. Wooten?
It's under my.
One moment.
No, I apologize for interrupting. This was limited to stuff plan here.
We'll see if there's a point that needs to, we can go back and forth and back and forth. We don't need to have strict guardrails for argument.
Your Honor, just very quickly, Harrison Floyd was indicted by a Fulton County grand jury for count 1, conspiracy to violate, count 2, conspiracy to commit solicitation, and count 31, influencing witnesses.
Oh, she got
He entered into
PowerPoint.
consent
She got
bound on August
PowerPoint.
29, 2023. The language was plain, and I still contend he violated 3 of the 7 conditions, those being 5, 6, and 7, but I just need one of them. Your Honor, the law is clear. It is clear that the trial courts have the power to revoke bond as long as minimum due process is applied. Your Honor, by this hearing, you've given him due process. The trial court has authority to revoke bond if following hearing, the trial court determines that the defendant violates those conditions. It is clear he violated the conditions. The standard of proof in matters initially setting a bond, the state has the burden of proving by a preponderance of the evidence that the trial court should deny bail to protect the community. Proof by a preponderance simply requires that the evidence show that something is more likely true than not. Condition 5, he shall perform no act to intimidate any person known to him to be a co-defendant or a witness in this case, or to otherwise obstruct the administration of justice. We've seen these posts, but certainly contacting the Georgia Secretary of State and Gabriel Sterling and calling them derogatory names is a way of intimidating. Whether it actually intimidated is not the result. It is, was it intended to intimidate?
How is that intimidating? What was intimidating about that?
Go through some things. Your Honor's been practicing criminal law a while. Moving right along, this offense of Jenna Ellis, and I was going to point it out, but you already did. How we can contend that a proffer is not evidence in this case, and you're so
this is not
dense,
anything.
you don't know that the proffer is evidence, when in her proffer, the condition is that she's a witness. They want me to say it's disingenuous. It's a lie, Your Honor.
A quote tweet? It's completely disingenuous.
This is Jenna Ellis. It's already Exhibit 23. I saw it a couple days after it was posted. Yes, I believe it was meant to both intimidate me. So does everyone else in the world who saw it, and to harass me, and also encourage others to harass me. That is common sense, but the witness has told you that is what she feels about it. Also, the negative comments that once again that Ms. Freeman has had to endure now for multiple years based on lies, he made sure that we're right back in that posture, and it's unacceptable.
What the hell are you talking about? She's not even on
For
Twitter.
democracy to work, we need little old ladies to come and volunteer to be poll workers. And what this lady has received is a pattern of being lied on and intimidation.
Little old lady.
And he started it again. And I think we can both agree, being called outside of your name, older lady, I don't want to offend Ms. Freeman again, by this, it's disgusting, and it is as a result of his posting images, which are also evidence in this case. No one can deny, if you read the indictment, which they have been provided, that this is evidence in this case, which is why she's mentioned 40 times in the indictment, but they want you to believe they don't know she's a witness.
How is this
it's ridiculous. I'm sorry.
How is this intended to intimidate her?
I agree with you there. With all the posts about Ms. Freeman, those are ones where she is not tagged. And so I know that we have Exhibit 22 showing that there is a reaction just to simply mentioning her. You know, would you agree with the defense that Mr. Floyd there's nothing prohibiting him from publicly criticizing the state's case generally?
What I would agree is that when he signed a consent order and the First Amendment can be limited for parties in a lawsuit, and Your Honor limited it. And the case law is very clear that there is a public good of keeping the community safe that you are required to do, which is why you made those limitations, and that his First Amendment rights to say whatever he likes, if they interfere with the trial of a case, can be limited. And I'm going to take your honor.
No question that it can be limited. What I'm wondering is, though, were they limited here to the extent that he couldn't talk about the case at all?
They were limited in the fact that he could not talk about the facts of the case, referring you again back to paragraph 57. It's not ambiguous, it's clear. It's a black letter. Cannot talk about the facts of the case. This video of Ruby Freeman.
You can't talk about it online anywhere?
Case, and it's in the indictment.
That's ridiculous.
Let me read you some of the law that we have, and this comes straight, Your Honor, from a Supreme Court of the United States case, Seattle Times Company versus Reinhardt, February 21st, 1982. So this is not new law. In the footnote, parenthetical 12 of 1718, although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting.
Interests?
For instance, on several occasions, this court has approved restrictions on the communication of trial participants, which he's a named defendant, he clearly is, where necessary to ensure a fair trial for a criminal defendant, which this could have impugned not only on his rights, but his 14 co-defendants still remain with him. Also, Your Honor, it says in that case, in the conduct of a case, a court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors. Your Honor, you restricted it when you signed this order. Not only what makes this so disgusting is he consented to this order. So this wasn't even put upon him. He agreed to this order. They want to tell you about 5 days. Those were 5 days he chose. They know that we tried to work with counsel, but that's irrelevant. He was given the benefit of the doubt. He was treated like every other defendant, although he had an open case. He was given an opportunity to cooperate with the rules of this case. And what he really did was sit in the court and refused to oblige by 3 of the 7 conditions of this bond order. So no, he does not have the right to communicate about facts of this case with witnesses, which he did with Jenna Ellis, which he did with Sterling, which he's very well aware of and was served. And it is not the state's fault if the defense is unprepared, which was their argument. We're unprepared. We don't know what's in the discovery.
That wasn't their argument at all. Not my problem.
Communicating with Ms. Freeman in this post.
Not my problem.
When you put something on a social media page that's reviewed by 400,000 and you put it in an open space, you have the ability to indirectly communicate with Ms. Freeman when you put it in the public space. Perhaps they could have some sincerity in that if he had a closed page that was not watched by many. Do you understand what I mean by a private or a closed page?
No.
That is not the status of his post, which is why close to 500,000 people saw it.
It doesn't matter. 500,000 people saw it.
Again,
he's not communicating with them.
Mentioning Jenna Ellis. Again, I guess they want you to believe they don't know Jenna Ellis is a witness in this case. On and on, Your Honor, and you have it. And again, I don't want to waste your time. And the response is just what you could expect. Miss Ruby needs a bodyguard or she's going to get Epstein. This is a direct result of his conduct, which is why you as the trial court have a duty and in fact did your duty to keep witnesses in this matter safe. Moving right along, if she'll live to see this day, there's no denial that as a result of his conduct, a witness was put in greater harm and greater hate was again spewed against someone that's had to go through this for 3 years.
This is a great question about that.
Condition 6, he shall not communicate in any way directly or indirectly about the facts of this case with any person known to him to be a co-defendant in this case. I guess they want you to believe they didn't know Jenna Ellis was a co-defendant.
She wasn't anymore.
Look at the post. It's part of the record in here. Jenna Ellis again saying she saw it, which means there was an indirect communication with him. Your Honor, I just need to prove he violated the order once.
Yeah, you
he knew what he was doing. They signed this order. They agreed to it. There was a good reason to have an order with these conditions. And what we're really here to decide today is does this order mean something or not? He doesn't get oh, I'm sorry, after I've already intimidated the witnesses in this case. It's too late. You should not have done this. You knew it was against the rules. You put someone in danger as a result of doing it, and now you need to be held accountable for it so that we can make sure that all of the defendants in this case get a fair trial and that witnesses are kept safe.
She's sweating. She needs like that.
Moving right along, Your Honor, you'll have all of these in your communication, there was some debate, again, lunacy and absurdity, that we don't know if this is Harrison Floyd. Your Honor can look at the post and see his image tying this to him. Jenna Ellis, again, in these posts. Authority of the court. Bonds in both felony and misdemeanor cases may contain conditions so long as the conditions are reasonable under the facts and circumstances of the case. I would suggest the conditions you gave him were reasonable, which is why they signed up to them and agreed to them. And Your Honor, it is not, we limit Fourth Amendment rights all the time in giving bond orders, giving someone the right to search. Same thing with First Amendment rights. Authority of the court. One of the court's functions is to balance the defendant's rights with the interests of the public. The public is Ms. Freeman, who served, keeping her safe. The public is also Ms. Jenna Ellis. The public is witnesses and jurors who will come and testify. Here, the bond conditions are not arbitrary and capricious because the conditions are a reasonable response to the trial court's functioning of balancing the defendant's rights with the public's safety interests while avoiding the intimidation of prosecution witnesses, which was the exact purpose here. But Your Honor doesn't have to find it was intimidating. You can say, you know what, all the witnesses pieces of shit, it don't even matter. I don't find that to be intimidating. Do you find—
What did she just say? What? You're the district attorney. You just like dropped the S-bomb in there. She dropped the S-bomb. She did. I know she did. I know she did. Oh, she's losing it. That's when you know you're losing it.
Which was the exact purpose here. But Your Honor doesn't have to find it was intimidating. You can say, you know what, calling witnesses pieces of shit, it don't even matter. I don't find that to be intimidating. Do you find they communicated? Do you find that they communicated with co-defendants?
Not with co-defendants. Ruby's not a co-defendant. Janet wasn't a co-defendant when she's proffering. That's not co-defendant at that point anymore.
Do you find they communicated with witnesses? If you find that, then you find that he violated the bond order.
No, those are two different things. Those are two different things. You're not allowed to intimidate a witness. You're not allowed to communicate with a co-defendant because the purpose of that is to keep them from working in cahoots with each other. So there's two different types of people that he's restricted. You can't be working in cahoots with people about the case, and you can't be intimidating witnesses who are going to be coming to testify. Neither of those things happened here. You didn't even come close. Not even close.
And you have to decide, do we have an interest as a society in keeping witnesses in this case safe? Do we have an interest in this case of keeping the other defendants from having a fair trial?
And this is like, they're trying to triple mask him here. This is like triple mask when you're dealing with a disease that's got like a mortality rate of 0.00000000012%. Not like any disease we've seen here in the last 10 years or so. I'm saying she triple mask and sanitizing.
Authority of the court. Although litigants do not surrender their First Amendment rights at the courthouse door, those rights may be subordinated to other interests that arise in this setting.
You read that already.
For instance, on several occasions, this court has reproved restriction on the communications of trial participants, which he is, where necessary to ensure a fair trial for a criminal defendant. There are other criminal defendants in this case. In the conduct of a case, the court often finds it necessary to restrict the free expression of participants, including counsel, witnesses, and jurors.
You might as well just start reading like paragraph 11 of the Declaration of Independence, because this has nothing to do with, it's remotely related.
Again, the site for that is Seattle Times versus Reinhart, 467 U.S. 20, 1984.
This is worse now.
Floyd violated his bond and it should be revoked. OCGA Ayala sets out 4 factors a court must consider when setting a bond.
She's very impressed.
He violated 3 of the 4. His rhetoric poses a significant threat or danger to witnesses in this case in the community.
Next.
He poses a significant risk of committing a felony committing trial. He poses a significant risk of intimidating witnesses and otherwise obstructing the administration of judges. The absurdity of the defendant's
judgment
argument. Defendant falsely claims that he does not know who the witnesses are. Your Honor, that's just a lie. It's just a lie. There's no other thing to call it. You're not aware Jenna Ellis is a witness?
But she's not co-defendant anymore, jackass. You're not allowed to talk with them about the case when they're a co-defendant. She was no longer a co-defendant when she's proffering. That's the point. Unbelievable.
So I know that it annoyed you to ask that question, but I wanted you to see in their own motion, they know she's a witness, and they should not have told you that.
No, they don't know that she's gonna. Oh, she's exhaling. Oh, this is the best, Fanny. You the best. Oh, this is great. She doesn't need. She needs Snickers. She needs Snickers.
Defendant Floyd in his
Girl
own
needs
motion refers to
Snickers.
Jenna Ellis as a witness. Defense motion, page 8, line 9.
I think she
Defendant
eats a
Floyd
lot
in
of
his own
Snickers.
motion refers to Ruby Freeman as a witness. More absurdity. In indictment number 231888947, Ms. Freeman is mentioned 40 times, but putting the defendant on notice, she is a witness. In indictment number 23SC18947, Secretary of State Raffensperger, who he tags, is mentioned 4 times. I think that puts them on notice that he's a witness.
No.
The defendant has the witness
No.
transcripts of the Secretary of State, Ms. Gabriel Sterling, and Ms. Freeman. They are aware with these witness statements that they are witnesses.
They're not
Defendant
intimidated,
states in
though.
his motion affirmatively that Mr. Floyd's post did not stir the pot against Ms. Freeman. Really?
Really?
You saw the
Yeah.
post. It
Yeah.
absolutely stirred the pot.
How?
And so for them to put that in their post when they saw, as he called them, the ugly, racist, violent comments, that is a
Racist
direct result
comments.
of his conduct.
He called her a racist. That's a racist comment for him to call her a racist. Saying that he's calling her a racist, that's a racist comment. In clown world, oh my gosh. Oh my gosh. That's what I'm hearing here.
However, a cursory review of the response to Mr. Post show that this to be another lie. Miss Ruby needs a bodyguard or she's going to get Epstein. Ruby is, if she lives till a trial. I'd love to see her daughter in the slammer, 2 corrupt losers, up into it, bury this under the jail. Ruby should be in prison. She's a racist.
She
Because
should be in
he's the one that's
prison.
scared she's afraid of white folks. Racist pig. It's no question that that is not true. Dirty damn rats. All of it is untrue. So they should not have stated it in their motion. Defendant wants this court to believe when you tag someone in a post, it does not notify them. The entire purpose of tagging someone is so it hits their feed and they see the post. Take judicial notice of that, Your Honor. You don't even have to, though. You had witnesses testify to it. They make this silly argument because it is clear that it's communication.
I just realized it's already 12:40 my time. So what I'm gonna do is this. I'm switching over on YouTube. Okay. I'm on YouTube on 2 channels. Okay. I'm on 2 channels. I'm here on Good Logic and I'm here on Trump Trial. Okay. And I don't like working on Good Logic quite so late into the evening when I'm covering Trump stuff. So I got like another half hour here or so. So I'm going to urge you. I'm going to put the link is in the description down below. I'm also going to put it. Let me see if I can put it up here. Let me put it up here for you guys. You guys think that Mighty White's racist? Okay. I'm gonna 49% say yes, 34% say no. Depends on the race of the U. All right. I'm putting in here. That is the link for where you could just click it. Just click it. I just pinned it. Okay. Just click it and watch. If you're on YouTube, if you're on Rumble, stay where you are. I'm going to keep coming here on Rumble. You won't even know anything different happened. Folks who are watching me on Good Logic on YouTube, I'm switching you over. So if you can hit like and subscribe in both places, all the better. All the better. But I need to shut down my YouTube Good Logic channel. Keep going on the Trump Trial channel, and I'm going to finish out the stream over there. So thank you, Eric. It's mighty Jew of me. Wait, mighty. Oh my God. Yeah. So anyway, that's what's happening right now. So I'm just giving that heads up there. So yeah, I'll still have that later to come back to. So I'm just giving you that heads up right now. Switch on over. Just hit the link. It's the same thing. You'll see me talking like the exact same time. It's the exact same thing, same time. Just click it and just watch on that channel rather than Good Logic, because Good Logic is shutting down in like 10 seconds or so. Really, it's like 7 seconds. If you think about it, we're down to like 5 seconds or so. I mean, really. So if you can just switch over. It's in the description. It's in the chat. I'm already past the 5 seconds. Oh my gosh, I'm past the 5 seconds. What's happening? What's happening here? I don't even know what's happening. Good logic, people. I'll see you guys tomorrow at 10. Trump trial. That's where it's at. Trump trial channel. That's where we're finishing this stream up at. And Rumble, folks, you're still where you're at. Okay. Now, let's get moving. I know I just lost like several hundred people. Hopefully they figure out how to get their way over here. Gotta do what we gotta do. Gotta do what I gotta do. Gotta start building that channel. Gotta start. So if you can hit like and subscribe while you're there, let's catch the rest of her thing here.
In violation of the bond order. They know it's communication. I submit to you it's direct communication, but it doesn't matter if it was direct or indirect.
No,
he violated his bond order.
It ain't direct.
In 2020, Ms. Freeman and her family members were intimidated by people as a result of her name being disclosed on social media. And it is this intimidation which Mr. Floyd was indicted to represent to the court that his recent post of accusing Ms. Freeman of the exact same things that were done before and indirectly targeted Ms. Freeman is absurd. Defendant wants us to court to believe that the last thing Mr. Floyd wants is for Mr. Freeman to form an impression he's somehow against her, except his post show that.
No,
it is Mr. Floyd accusing Mr. Freeman of his post of being a fraud.
She can't even point to the part that's supposed to be intimidating. She can't. I guess the Epstein part and needing a bodyguard. But Ruby's not on Twitter. She's not on Twitter.
Your Honor, all we're asking you to do is exactly.
If he said the same thing on some Bangladeshi social media app, is that also intimidating her? You're not aware of it. How the heck? It's so stupid.
What the defense asks you to do. Read the court order. Look at the evidence. He violated this court order. It is unfair to those witnesses that are just coming, first, to do their public duty as an election worker, and second, to do their public duty as a witness. And there are real consequences for allowing defendants to intimidate witnesses.
Not really.
Your Honor, we're asking that his bond be revoked and he be remanded today.
Today. Get his ass today.
All right, I'm going to allow the state the last word. Mr. Kasharov, if you have a few other points you want to make.
Yeah, I'll be brief, Your Honor.
Break it. I really hope he breaks it down, the difference between co-defendants and witnesses against, and that he can't work to communicate with them about the case. So Jenna Ellis is no longer co-defendant. So the proffer there, it has to be that he's trying to intimidate her. And he's not trying to intimidate her if he says that she's a traitor and a loser.
You know, as you know, I've not ever contended that Miss Ellis isn't a witness or that we didn't know she was a witness. I'm not sure where that came from. My motion said, our opposition says she's a witness. We admit that. The state's argument is that anything on social media posted about that Harrison Floyd posted about this case is automatically an indirect communication, if not a direct communication. That's absurd. And that's where we're running into trouble here. Judge, I would submit you focused in on one particular tweet, which was Jenna Ellis. And I'm going to go back to her tweet. That tweet is a shout out to the Twitterverse at large. Yes, I think it walks up close to the line, but if you understand the world of Twitter, or X as it's now called, that's not how people communicate. It's a very ineffective way to communicate.
I just want to pause and show you something here. If you remember, like I showed you like a half hour ago, my Twitter, right? And I had like 5 notifications at that point. Right now, I hit that 20 plus. If I get another 1,000 notifications, it'll still say 20 plus. And my account is a joke next to Jenna Ellis's. It's a joke. That's how fast it fills up. That's how fast this thing fills up. And when I click on it, you'll see here, because and this is not a sort of humble brag or anything like that. I'm simply just trying to point out, it's like you don't notice anything. It's very hard to see anything. If someone points out at you, you have to like really be looking through when you're clicking on it. And if there's 1,000 of them, there's no way you're scrolling all the way down and scrolling down to see what someone said. And on Jenna Ellis's account, if someone said it 20 minutes before she checked her notifications, it'll be like 200 notices down, 400 notices down. It'll be impossible for her to find it. There's no way she'll find it.
If he really wanted to communicate with her directly, he would have simply sent her a notification and called her a liar or whatever. And he could have even called that out. That would have been a clear violation of the protective order. The other point that the district attorney made was that oh, we said we didn't stir the pot. Yeah, we didn't stir the pot. You see, the district attorney stirred the pot. They've been stirring the pot since he got arrested, Judge. From the very first occasion, I never got a call about Mr. Floyd getting bond. Rather, I have Ms. Willis and Mr. Wade apparently recorded my colleague up in Maryland, which, by the way, it's a two-party state. It's a felony to record without permission up there. They recorded my colleague, and he said, I don't know anything about the bond. I was handling his case to come here to Georgia. So this idea that he's been given all these chances, et cetera, I think that's hogwash. Now, this idea, though, that we didn't stir the pot. All the evidence that you have, the views, they're wholly dependent, Judge, when they were captured, when you looked at Twitter and when you captured that image. When they filed this motion to revoke bond, just like when they filed the motion for the protective order, if you recall, Judge, I was in court and I said we had gotten numerous calls from the media that they were pestering us, and you said, well, we should all expect some of that.
I'm an idiot.
And I agree, you should in this case.
You're right. I should have rated myself.
This is not exactly right.
I'm such an idiot.
Because when they file a motion to revoke his bond, they're all in the back watching us. When they file the motion, it immediately causes a spike and everybody starts searching everything. So they can't use that as evidence against Mr. Floyd. I think that is absurd. The other thing I would leave you with, Judge, I really believe that the words of this court order are pretty clear. And I think the only thing that you have to discuss or to analyze today is whether you believe he was communicating with Jenna Ellis in that one post. I think that's the only issue that you are faced with, because it's an indirect tag. Now, it's not an indirect communication, and as I've said, the Twitter help file is just dispositive on that. It's a shout out to the Twitterverse. Could it be used as a direct communication? Well, indirect. I'm sure it could be used as an indirect communication. But if you search yourself, Judge, and look up Jenna Ellis and send the money back, I think she raised over $200,000 and before she entered her plea, you'll find hundreds of thousands of posts telling her to give it back. Now, maybe she was directed to Mr. Floyd's at some point by the state. I don't know. We don't, and we should not chill speech. He has the right to make political speech. He has the right to talk about the facts of this case in Twitter, as long as he doesn't communicate with another defendant or a witness. Now, we don't know all the witnesses that are in this case. Like I told you before, I know a fair number of them, but I have a list of unindicted co-conspirators that I'm just trying to figure out who they are.
I'd like to move on to page 4.
I don't have a matrix of that. If we do, it's in the discovery somewhere, and we're still searching through that morass of information.
So you were not provided the witness list used during the trial we had prepared for Mr. Chesbrough?
No, I was not, Judge. I don't recall getting that list at all. If they did, I couldn't sit here today and tell you they didn't put it with this mountain of stuff, but the way they turned over discovery, I've never seen anything like it. They just handed, 80 folders down, yet you find this one little GIF image, a little picture that belongs to another file that's down a different tree, 50 folders. It's absurd. That's absurd. So at the end of the day, I think the rule of lenity is appropriate here.
Mm-hmm.
If the court feels that something is amiss,
Rule
or
of
you want to
lenity.
correct something, or we need to make something more clear.
Rule of lenity means that if something can be interpreted in more than one way, you must interpret it in favor of the defendant. That's the rule of lenity, which applies in all criminal matters.
I think we need to give Mr. Floyd the benefit of the doubt. This is not giving him a second chance. I'm not asking for that because I don't believe he violated the words of the bond order. I think the bond order is crystal clear. Do I think he walked up close to the line? Yes, he did. Have we had discussions about it? Sure. But in terms of the last part with the 13th and 14th, when were accused of, quote, leaking a video, that video wasn't leaked. There was no protective order on any of those proffer videos. That wasn't even a leak. Yet Mr. Floyd's November 13th and 14th posts are responding to that purported leak because the district attorney absurdly put in a typo for my colleague where he said, we are the source of the leak. And he then sent another email back pretty quickly that said, we are not the source of the leak. I'm sorry, that was a typo. I typed too fast. They did mention that it was a typo in their motion, but they only included one email. The press picked up on that one email and things started to go crazy. That's the nature of this case. So if we're going to limit speaking, you know, every time Ms. Willis goes to Washington, D.C. and attends one of these events, we get spikes in Twitter. The same time that he was making these other comments, that's when she was in D.C. at these events. So the words of the court's order are clear. The burden has not been met by the state for the, I'm positive the burden has not been met for the concept of intimidation. That's a legal definition under Georgia law, and it requires one to be objectively and put in reasonable fear of harm by the words that were spoken, not by responses, not by any of that stuff. And then with respect to the last two, paragraphs 6 and 7, you won't communicate with. Means alongside it, I won't go to this man and say, I communicate with you. I want to talk to you. As opposed to me addressing you here, knowing full well he can hear me. And saying, well, John Morrison is our co-counsel. I'm
Great
not
distinction.
communicating with him, but he can hear
Great
me.
distinction. Very important distinction.
So the idea that he didn't communicate with about the facts of this case, as I want to express to Your Honor one more time, it's not that he can't talk to a witness or a co-defendant. What Ms. Willis said about that is absolutely incorrect. That's not even what the court order says. The court order is specific. You cannot talk to another witness or co-defendant. You cannot communicate with them about the facts of this case.
All right, you made
The
your
whole
point.
purpose of that number 6 and 7 is to avoid collusion. That didn't happen here. What we have here are First Amendment issues.
There's no
You want to
claim
curtail,
that
I
happened.
would submit, Your Honor, we should adopt what the president's bond conditions, where they explicitly mention the First Amendment issues on Twitter, because the president is known for that. So if they felt that this was included in his bond motion, they should have put it in there. They had the opportunity to do that. Thank you.
Well, I'm not going to be long. The bottom line is the defendant didn't respect the order of his court. He violated it. If you have questions about intimidation, don't go to that paragraph. Go to paragraph 7. Although you have a witness, Ms. Jenna Ellis, telling you she felt intimidated, and Von Du Bois, who represents
She didn't feel
another
intimidated.
witness, telling you that he interpreted that his team, to include his client, interpret that as intimidation. But you don't need it. All you need is paragraph 7, which says
How
he has to
gross that she
communicate.
told that
This
investigator she
notion
felt
that
intimidated.
tagging someone doesn't
Such a
give
lie.
notice to them
She's a liar.
is really lunacy.
Jen Ellis is a liar. And the only lunatic in this courtroom is Fani Willis.
All right. I'm going to compile my notes, and I'll be back in time. We can hold in place. So just a few thoughts to share. And the
All
first,
right,
I would
here we
just
go.
say how we got here. At the outset, I'll just note that at the time of indictment, we were in this courtroom in the middle of another murder trial, so I was not able to conduct the first appearance for Mr. Floyd. But throughout that week during the trial, we were presented with these consented bond orders, which were negotiated by the parties, and that I signed without a hearing. And Mr. Floyd agreed to abide by the terms of it. And I think it's clear from the case law, there is no constitutional right to bail. And a bond can contain special conditions as long as they're reasonable.
He's
under
freaked out.
circumstances.
This doesn't start. It's not a nice
And
starting
often those
start.
can curtail or even eliminate defendant's constitutional rights under the First Amendment, under the Fourth Amendment.
This
And
is sounding like
contact,
I'm
we
sending
see
you to
that quite
jail.
commonly. And the question becomes, the trial court has to balance the rights of the accused, as well as the public safety interests that are raised by any particular case. But I'll also note that a defendant is generally allowed to publicly criticize the merits of a case, to say that the prosecution doesn't have a case, to challenge the strength of the evidence.
Say Fani
To
Willis
speak his
is
mind.
fat loser.
And I don't see anything in this consent bond order that limited general criticism of the state's case.
And the fact
Each
that
of
they
these
stopped-
conditions
that Fani Willis is
had components to
incompetent.
them, had preconditions, but there was no general limitation of talking about this case. But obviously that criticism not cross a line and ever evolved into witness intimidation. And I think as the defense was willing to concede here, Mr. Floyd seems very boldly willing to explore exactly where that line lies in this case. And I think the state has made a compelling argument on many of these points. But in categorizing these statements.
He's so waffling, this judge.
On the first point,
They made a really compelling argument.
Intimidation. We don't see, as we might see in these bond conditions, as they're traditionally understood, someone posting the personal info of a witness or a co-defendant. We don't see someone directly messaging, again, as that's traditionally understood. And
you're toying with him.
We
think
don't
it's
see
intentional.
in the wording an explicit indication that something ought to be done about these individuals or that they should be targeted in some way. I read these as seeing more that someone is wanting to defend his case in a very public way. And so on the question of, and especially when it comes to the public officials, I think we've, as Mr. Sterling testified, when it comes to intimidation, they've endured far worse than is presented in this motion. I think it becomes a much closer question when we start talking about whether this is direct or indirect communication. And we're getting into also kind of a question of at what point is someone responsible for the response of others? And I don't know if those are necessarily settled questions.
I think that's pretty
under the
settled.
traditional bond limitations that we
That's
use,
pretty
and the
settled.
phrasing that we used in this case. And
It's pretty ludicrous to be responsible.
ultimately, I think that, first of all, the defense argument that
I think this is,
there's no knowledge that
the
these
fear
were
of God in
potential
him.
witnesses. That's not one that an argument that I'm buying. I think that we can't hide behind a veil of ignorance when certain witnesses have testified before the special grand jury or are very much known to be involved in the facts of this case, or just recently pleaded guilty and are known to have a public cooperation provision. I also think that when we're talking about the facts of this case, that is a broadly understood term. And if someone is just denigrating another person who's known to be a witness and talking in reference to their proffer, that's also satisfying that precondition. But when it comes to the question of indirect communication, again, I think it comes down to, while there may, I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and that communications he made wound up before the eyes and ears of potential witnesses and co-defendants. But not every violation compels revocation. And so I am stuck on the question of notice, and that the bond conditions as written in my mind were not specific enough to account for the nuances of social media. So I think the ultimate result of today's hearing is that it's very clear to me that this bond needs to be modified. And I think it needs to specifically prohibit any public comment concerning Ms. Freeman, concerning her daughter, and concerning other witnesses that need to be included, because even if he's not directly or indirectly communicating with him, however we define that term, I think the public safety interests raised as a result of today's hearing indicate that his actions have a consequence. And because he's under the conditions of this bond order, the court has the ability to curtail and protect that interest. So ultimately, what I would be asking for is for a recommendation from the state, but I would also allow the defense to respond of exactly how they would propose adding or modifying these bond conditions. And I will then take those under advisement and enter a modification on the record. And nothing from today's hearing should be seen as curtailing the state's ability to refile such a bond revocation motion immediately upon an additional violation. And I think that it also is very
He's
much
totally just
dependent
trying to
on the
scare him.
specific facts of the tweets and communications at issue here. And it can't be so broadly defined to cover all other co-defendants. So on the issue of modification, I think that's something that we can revisit and let time to consider, unless there's something the parties would like to address now and want the court to be able to consider specifically what they would like to see as a modification. Or that's something we can follow up, but the court is available and ready to enter that as soon as it's conveyed. Anything, Ms. Willis, that you would like to add?
Obviously, we're very concerned about the safety of Ms. Ruby Freeman.
No, you're not.
Clearly,
No, you're not. You would have had him take it down. If you were
and
very
conduct
concerned,
is
you would have
not
had him take it
showing to her,
down.
showing to
I'm
other
disappointed in the
people
judge for not bringing that up.
capacity. So, you know, we respect the ruling of the court, but take exception. This defendant is very well aware of what happens when he tweets about Ms. Freeman. We do not believe it is appropriate for him to make derogatory comments about anyone. He can publicly criticize me all he wants. I don't value his opinion, it doesn't matter. But what he may not do is publicly do things that intimidate witnesses. And so that needs to be clear. He should not be able to tag him so that they are communicated with or put them in open space so that Ruby Freeman now may have to move again and get another advisement from the FBI. And so if you are, I would ask that before Your Honor leaves here today, that my team be allowed to sit down and that the defendant personally sign off on an agreement stating that he, an initial each clause so that it can be made more clear that he should not contact and intimidate witnesses in this case.
I don't have any concerns with what you've raised. Mr. Morrison, Mr. Cattrall.
Briefly, Judge, I'm not going to sit down and initial language that I haven't seen, number one, or have time to look at, cogitate, ruminate, pontificate over.
Yeah.
I think the appropriate thing for us to do is what you.
Why should he sign anything?
We'll submit our orders, if you take what you think is appropriate, reasonable.
Yeah.
And it's that way.
Yeah. If
But
the
I
court
think
makes me
she's stepping
sign it,
back
I'll
today,
sign
and
it.
we can get it worked out, then he can be loose.
Well, I think there's still time to the day. Why don't we see how far we get? I'm not going anywhere. And again, I don't think we're writing a treatise here, but I think there needs to be something more explicit and a little bit more definite. And it can be as all encompassing as we need to be. And if we need to go back on the record about that, we can. So how about I will check back in with everybody closer to 5 and we'll see where we are. And if we need more time, we can take more time.
Your Honor, does anyone have a jury room where we could meet?
We do have several rooms. I think the state could use the jury room if they'd like to, and we can find a side room here if we can unlock that for you. Deputy Scott, is that unlocked?
All right. There you go. And that's how she lost it. She lost it. Oh my God. My God. She was so mad. She was so mad. It was delicious. Delicious. Yeah, that's a movie reference. That's really, I just dated myself with that movie reference. Delicious. Anyhow. Yeah. So that was fun. I had a great time. I hope you guys had a great time with that. Yeah, she was really not, she was not happy. She was not happy. She's like, he found like 5, 6, 7. Just give me one. I don't need to have all of them. Just find one of them, please, for the love of God. We think this is really, really bad what he did and staring and like, she just say Jenna Ellis is not a witness. That's lunacy. This is lunacy. This is crazy. Woo. Woo. Wow. Okay. So thoughts. Here are my thoughts. His counsel, I thought was, I wasn't crazy about the style and it was a little bit stilted and stuff like that, but effective. And effective is more important than style. Scale of 1 to 10, I give him like a 6.5, 7. I thought Fani was very unimpressive. I'm not going to kid you. I mean, yeah, she quoted the law, that she needed to, but I thought that she seemed kind of as look, if you're a district attorney, you're not going to be, you can't be utterly terrible. It's not going to be, you're not going to be like, Darryl Brooks screaming grounds. She's a freaking district attorney. But as district attorneys go, I don't think she's very scary. I don't think she's like a really intimidating prosecutor. I've seen way, way, way more intimidating prosecutors. Like I think Binger was not like a great district attorney, but he's like as an attorney far more just far more direct and able to attack in an annoying sort of way. She's definitely on the bottom end. I put in the bottom like 25% of attorneys that I've seen in these trials that I've been covering. She's really not very good. She's not. It's really good news for Trump. I don't think she's a very good attorney at all. I think that she's a pretty poor attorney. And for her to like not realize the problems that she was having. Look, you only have the case that you have, but she's the one who chose to come forward with this. She should have realized that, hey, there's you sort of like, first of all, she didn't prep her witness well at all, because I was pointing out better answers he could be giving. That if, for example, he could have been saying that if he wasn't trying to get their attention, wasn't trying to intimidate him, why would he put the ad in? He could have just written Gabe Sterling, and then everyone would have known who he was talking about without putting the ad in. But she didn't prep him well, either because she doesn't know how Twitter works or whatever. But that's a poor job. That's a poor job. That's a pretty key point that Mr. Floyd got away with there. So, yeah, I don't think I think she's in over her head. I don't think she's very good at what she's doing. And that's really good news for Trump if, in fact, he ends up going to trial in March, the way that they're trying to hail him in there. I believe March 4th is when they're planning to have him in there. I'm urging you to like and subscribe, because I will be covering that trial and anything related to Trump. Even this. Is this related to Trump? Yeah, it is. It's co-defendant in his case. But I'm saying is that's not like a Trump trial per se. I think it gives us insight into what he's facing with respect to Georgia. I fully anticipate that Jack Smith will be a better litigator than Fani Willis. I fully anticipate that he's going to be a better attorney than Fani Willis. I haven't seen him litigate, but I'll tell you, I'd be surprised if he's as poor at his job as Fani Willis seems to be at hers. That is our show for tonight. Tomorrow, I plan on going through that X trial, the Elon Musk, the X complaint that was filed against Media Matters. I definitely plan on covering that, probably on Locals, which is at goodlogic.locals.com. That's goodlogic.locals.com. If I don't do it then I'm probably going to end up covering it at some point tomorrow night, and I'm streaming then. If it's not Trump related, it's not going to be on this channel. I mean, it'll be on Rumble. Yeah, always on Rumble, because you Rumble folk, you know that I love you way more than you love me. Way more than you love me. 537 people watching me. 537. How many likes? How many likes? I don't even know. How many likes? 537. 123 likes. I feel like I'm one of those women who's like, just like, I keep coming back, and like the love just doesn't follow. Still can't get to 10,000 followers. If you're here, like, subscribe. That's whether you're on Trump trial channel, Trump trial channel. Try saying it 3 times fast. Trump trial channel, or on Rumble. And if you're over in Locals, yeah, by the way, I don't see you, Rafe. Good idea, self-rate from Good Logic to Trump trial. Yeah, I plan on doing that. I plan on doing that in the future. I actually had to set permissions up, which I hadn't set up before. But if next time I do this, I'll end up rating myself. And we'll say, Good Logic raid. That'd be pretty funny. That's like what anyone with half a brain would have done. But next time. I thank you all for joining me. Tomorrow, goodlogic.locals.com. Make sure you're in there for tomorrow's little hangout, and I will catch you all then. And then tomorrow night as well. Till then, take care of yourselves. As always, look out for your loved ones. Be happy, eat the bugs, and Godspeed.